Good afternoon, everybody. My name is Christy Matheson. This is Health Coverage Insurance and Financial Services. Welcome. We have one public hearing, one work session, and some language review, but I'll start with introductions with Representative Chimino.
Thank you, Madam Chair. I'm Representative Mary Grace Chimino. I represent House District 83, which includes the towns of Bridgeton, Harrison, and Denmark.
Good afternoon, Representative Michelle Boyer. I represent House District 123, which is most of Cape Elizabeth.
Hello, I'm Sally Clucci. I represent House District 52, which includes the communities of Bowdoin, Bowdenham, and Richmond.
Good afternoon. I'm Anne Marie Mastracchio. I represent House District 142, which is part of the city of Sanford and the village of Springfield.
Good afternoon. I'm Representative Josh Morris. I represent House District 91, which is Turner, Leeds, and Wayne.
Good afternoon, everybody. Welcome. Representative Paul Flynn. I represent District 63, which is Winslow, Albion, Freedom, and Unity Plantation.
Good afternoon. I'm Representative Rolf Olson, District 86, which is Raymond, Castro, Fry Island, and a bit of Poland.
Good afternoon. My name is Bob Foley. I represent House District 145, which is most of the town of Wells.
And I am Senator Donna Bailey. I represent Senate District 31, which is Buxton, Old Orchard Beach, and Saco. I serve as the Senate co-chair, and I do need to excuse myself. I need to be in Zoom court, but I hope to come back soon. Thank you.
And my name is Christy Matheson. I represent District 151, Kittery, and I do serve as the House co-chair. And we have LD 2233, an act to combine the Board of Licensure and Medicine Board of Osteopathic Licensure into a single licensing board for all physicians and physicians' assistants. And I think we have somebody from the board that would like to introduce the bill. Thank you, Mr. Terravino. Welcome.
Thanks.
Thank you. Welcome.
Thank you. Good afternoon, Representative Matheson and members of the committee. My name is Tim Terranova. I'm the Executive Director of the Board of Licensure and Medicine. And I would like to thank you for introducing this bill and working with us to get this in front of you this session. As you know, BOLEM licenses and regulates allopathic physicians and physician associates. Its primary mission is to protect the public health and welfare of Maine by ensuring that those who are licensed to practice medicine or render medical services are ethical, professional, and competent. Approximately 18 months ago, representatives from BOLEM and the Board of Osteopathic Licensure, or BOL, met to discuss the possibility of merging. Those meetings resulted in the introduction of LD 805, a resolve to direct the Board of Licensure and Medicine and the Board of Osteopathic Licensure to conduct a study regarding the feasibility of combining those boards. Due to the fact that representatives of the boards had already formed a work group and started regular meetings in January 2025, the committee voted not to pass on LD 805 and sent a letter to the boards instructing them to continue their work and report back in January 2026. The work group met once a month in 2025. The first several meetings were focused on gathering information and included presentations from outside organizations and interested parties. The rest of the meetings were focused on what a merged board would look like and how to ensure that our common mission to protect the public would be upheld and ultimately strengthened. These meetings revolved around creating a draft statute, allowing board members and the public to see what a merged board could look like. This involved items such as keeping the current requirements for licensure for each profession, creating 2 investigative committees to share the workload, and updating the adjudicatory hearing process. At the beginning, there was discussion of reducing the number of board members. The number changed throughout discussions, but in the end, it was felt that keeping all board member positions was the best option and would enhance the new board's ability to protect the public. We reported back to the committee in January with our written report and a draft statute. As a reminder, our report and presentation to this committee detailed the reasons needed for the merger, including the need for separate investigative and hearing panels, given time constraints, I won't go through each part, but I'm happy to answer questions. And I want to thank the committee again for its support during this process in introducing the current bill. I also want to thank the board members and staff from both boards who spent a significant amount of time and effort participating in this effort. I know there are many osteopathic board members here today, and I know that we have BOLM members online, at least to watch, if not to testify. This process was not a straightforward rubber stamp of merging the boards. There was difference of opinion and conflict over various issues. But in the end, the work group and the boards were able to come to terms and agree on a way forward that best protects the public. The work is not finished, and the work group has continued to meet and discuss plans in this case in case this legislation passes. Part of that work has resulted in a draft timeline and checklist, which are attached to this testimony. As you can see, the work group continues to think and plan proactively. You may hear testimony voicing concerns about a merger. Some of the testimony may include examples of how the two professions interacted in the past, concerns about changing licensure requirements for professions, failure of one profession to understand the unique traits of another profession, and loss of professional independence. These are valid concerns, and they were heard and discussed by the work group as it worked through this process. The work group has done its best to be responsive to those concerns. However, I would like to point out that there is an implicit difference between the role of a licensing board and the role of a professional association. Boards are created by the legislature to protect the health, safety, and welfare of Maine citizens. Professional associations are established by professionals to protect and promote their profession. Our boards have long histories of collaborating with their respective professional associations. However, a merger may not align with some of the association goals, and that's okay. The work group and both boards believe the draft statute strikes the right balance while maintaining the focus on the public protection purpose of licensing boards. We look forward to continued collaboration with the professional associations. I would like to point out two small items with the bill. First, as indicated, the bill will need a fiscal note. We expect to incur one-time charges of approximately $200,000 related to the merger. We are dedicated revenue and we have reserves. This won't result in an increase to licensure fees. However, the effective date of the bill is January 1st, 2027, and we would need those funds before that date in order to pay for the work that's being done to prepare for that. And so we're not sure the best way to do that. We're open to the committee's guidance regarding that, and I have one possibility in that testimony. The second piece, which is not in my testimony but has come to our attention, is because the effective date is January 1st. The voting of board leadership, it says the first time that should happen is July of 2027. It really needs to happen in January of 2027 so that the board has leadership, and then move to July following that. And July works well because board members' terms start and end June 30th, July 1st. So July 1st is a better time to do that. In addition, I do just want to point out that there is LD 2088 that is still currently active. And if that passes, some of this legislation may need to change. And I've listed what would need to come out if that passes. Thank you for the opportunity to provide these comments, and I'd be happy to answer questions now or at the work session.
Questions from committee members? Representative Boyer?
Thank you, Madam Chair. Thank you, Mr. Terranova. Can you just help me? I think I didn't totally understand the 200,000. The board does have the funds for that.
Yes, we have reserves that will easily cover that.
Okay.
But it's not allocated. So we need it allocated so that we can spend it.
Okay, that's the part I was missing. Thank you.
Yep.
Additional questions from committee members? Seeing none, thank you for your testimony.
Thank you.
Is there anybody in the room like to testify in favor of this bill? Welcome. Go right ahead.
All set?
Yes, thank you.
Good afternoon, Representative Matheson and distinguished members of the committee. My name is Paul Vinsel. I'm an osteopathic physician living in West Bath. I'm licensed in Maine. I'm also a physician member of the Maine Board of Osteopathic Licensure. I speak today as a private individual and not as a representative of the board. I want to support LD 2233. I graduated from the University of New England College of Osteopathic Medicine in 1984. I take great pride in being an osteopathic physician, and I understand the difference in the history and philosophy between osteopathic and allopathic professions. The citizens of Maine are well served by availability of osteopathic and allopathic physicians. When I, as a member of the board, review an application for licensure from an osteopathic physician, I see the applicant's diploma in the file, and I can't help remembering my day of graduation from the University of New England. Though there are differences in education and history of osteopathic and allopathic medicine, both professions must deliver treatment following the same ethical, moral, and professional guidelines and regulations. For this reason, it makes sense to combine the two licensing boards into a single board. The purpose of the Medical Licensing Board is to protect the health and safety of the people of Maine. As part of my medical practice, I had the opportunity to precept family medicine residents. These residents were both osteopathic and allopathic physicians, learning their specialty. I expected all the residents to develop the knowledge and skills to become excellent family medicine physicians, whether they graduated from an osteopathic or allopathic medical school. In Maine and every other state I've practiced, osteopathic and allopathic physicians work collaboratively with all members of the medical team. Just the task force from the two boards worked for more than a year and felt that combining the boards into one medical licensing board with equal numbers of osteopathic and allopathic physician representation was the best plan to protect the health and safety of the people of Maine, and I support that decision. Thank you for the opportunity to speak in support of LD 2233, and I'll be happy to answer any questions in person or by email.
Thank you very much. Questions from committee members? Seeing none, thank you for your testimony. Are there additional people who would like to testify in favor of this bill?
All right, good afternoon, Representative Matheson and members of the committee. My name is Laura Harper. I'm a senior associate at Mooseridge Associates. I'm here today testifying on behalf of my client, the Maine Association of Physician Associates, and Kathleen Monahan. So these are her words. My name is Kathleen Monahan. I'm the president of the Maine Academy of Physician Associates, or MEPA, a Dover Foxcroft resident, and I practice medicine in occupational health and urgent care. MEPA is a nonprofit organization that represents over 1,000 PAs practicing in Maine and the patients we care for. And today, we're testifying in support of this bill. Maine does not have a licensing board dedicated to PAs. Instead, the Board of Licensure of Medicine, or as we call it, BOLM, and the Board of Osteopathic Licensure, or BOL, both offer a pathway for PAs to be licensed. It is up to the PA to choose which board they want to be regulated by. Prior to 2016, PAs had the option to be licensed by both boards simultaneously. In 2016, the law changed, and PAs needed to pick which board they wanted to be licensed under on a permanent basis. The majority of PAs chose to be licensed under BOLM, simply because that is where they were already licensed. For PAs who chose licensure under BOL, their license status changed to reflect that they were inactive, their license had been withdrawn or terminated by the licensee, or they had failed to renew on the BOLM website. While all these descriptions are accurate, they only give half the story when it comes to verifying a PA license. There's no additional message right now if you look at these entries informing the public that the clinician is still licensed. They're just licensed by a different board. So for the PAs who have been practiced since the 2016 law change and chose BOLL, it's been frustrating to explain to our patients, employers, and other professionals that we are indeed licensed and in good standing. What needs to verify with BOLL, not just BOLM. This inconvenience elevates to impacting patient safety when it comes to the pharmacy. PAs have found their scripts rejected by pharmacists when the pharmacist only seeks license verification from BOLM and not BOLL. This has a negative effect on the relationship and trust between patients and clinicians. It puts more strain on our support staff, who then need to follow up with the pharmacist, explain how there are two boards, and at times even walk that pharmacist on the phone through the verification process. And of course, this causes a delay in the order being filled for the patient. This is just one example of the positive impact a joint board will have on Maine PAs, and one of the many reasons that MIPA supports this bill. We have been present at the many joint BOLL and BOLL work sessions over the past year, and we've had the opportunity to weigh in with our thoughts. We are encouraged by the decision to have an unchanged number of PAs represented on the joint board, as well as representation on all committees. BOLM has been very proactive in reaching out on how many PAs will be affected by this change, and we're told that it's only approximately 6 that will need to make licensing changes. We've been reassured that BOLM will work with us and these individuals to make sure the process is as streamlined as possible. So we look forward to this continued collaboration, and we urge you to vote off to pass.
Thank you. Questions from committee members? Seeing none, thank you for your
you.
testimony.
Good afternoon, Representative Matheson and members of this committee. My name is Ann Sedlak, and I'm the Director of Advocacy for the Maine Medical Association. For this testimony, I am testifying on behalf of just Maine Medical Association. The Maine Osteopathic Association will be submitting their own testimony later on. The Maine Medical Association represents both osteopathic and allopathic physicians in our membership. And we appreciate the work of BOLM and BOL over the last 2 years to develop this merger. We have closely monitored the progress, and we are grateful for the transparent manner and the undoubtedly very hard work it took for the boards to get to this point. We feel this proposed merger is solid in its current form and is the best course of action for our members and for the public. Since our membership comprises of both allopathic and osteopathic physicians, it can complicate our work in advising our members and the public on the different professional considerations through the board, including on liability and compliance. One example is I had to give a presentation to some free clinics about how to have more physicians serve in a volunteer capacity. Through BOLM, there's a specific volunteer license which allows for physicians, allopathic, holding an inactive license to provide medical care to needy and indigent persons for zero compensation. BOL does not have a similar license category. That can be confusing to our members, but it's also confusing to the members of the public and to those clinics who only know them as physicians or doctors. We also wanted to note appreciation for a longstanding issue for our members, which is to separate the investigatory and adjudicatory process of the board. There should be a distinct division between the investigators of a physician license and those determining the ultimate fate of that license. We believe this proposed merger provides a just and fair decision-making process, and grateful for the board including those processes here. We would just suggest making it clear in the statute that the Assistant Attorney General advising those panels is also a separate person. Finally, we want to note that we greatly value and appreciate our colleagues at the Maine Osteopathic Association, and we respect their testimony in this merger. We appreciate that our associations can take differing approaches and still work together on many other issues. Thank you for considering the thoughts of our members, and I'm happy to answer any questions.
Thank you. Questions from committee members?
Wow,
Seeing
thank
none,
you.
Thank you. Is there additional people who would like to testify in favor of this bill? you.
Good afternoon, Representative Matheson and members of the committee. My name is John Brewer, DO. I'm an osteopathic family physician who started practice in Maine here in 1986. I'm also secretary to the Board of Osteopathic Licensure, but I'm testifying today as an individual osteopathic physician in support of LD 2233. As you are aware, presently two separate boards oversee allopathic and osteopathic physicians, and in addition, physician associates. In the interest and safety of Maine citizens, LD 2233 is an opportunity to merge these boards into one robust working unit that shares resources, both physical and personnel-wise. It has all the potential to make the tasks of the boards more efficient, expeditious, and cost-effective while augmenting the ability to keep Maine citizens safe. One can only see this as a common sense goal that embraces our mission as a board in a more modern world. I have attended all but one of the meetings over the past 1.5 years of the work group to study the feasibility of the merged board scenario. I have been impressed with the hard work, camaraderie, openness, professionalism displayed as we have maneuvered through this very dense maze of options. Spirited conversation, ideas and criticisms, write-up and rewrites were the order of the day. Valuable input from doctors, professional organizations, and civilians lent further insight into the mix. Through these discussions, LD 2233 emerged, which contained an important priority, that there be an equal number of osteopathic and allopathic physicians to balance the scales and represent both disciplines. The issue of equal footing was a major concern in our year-long debates for my osteopathic colleagues, many of whom had been victims of discrimination. I myself was subject to this bias. I can tell you it was neither pleasant nor warranted. But times and attitudes can change, fortunately. I can now say with great confidence, comfort, and openness that the mutual spirit of both boards, with outstanding dedication and support from their staff, moved in the right direction. The safety of the fine residents of Maine will ultimately benefit from LD 2233. I feel LD 2233 speaks for itself, a legislative process that encompasses and supports all we as osteopathic and allopathic physicians do. We practice excellent medicine, keep our patients safe and healthy, and do no harm. I endorse LD 2233 and urge the committee to support this hard work and collaborative effort done by and unanimously agreed upon by both boards. Thank you for the opportunity to speak with you all today, provide comments, and I will be happy to entertain any questions now or in the future.
Thank you.
Thank you.
Questions from committee members? Seeing none, thank you for your testimony.
Thank you.
Thank you for your service since 1984.
It's been an honor.
Are there additional people that can testify in favor of this bill?
Good afternoon.
Good afternoon.
I am Rachel MacArthur. I am the Executive Secretary of the Board of Osteopathic Licensure. And unfortunately, our board chair, Christine Monroe, could not be here today. So I will be reading her testimony on her behalf.
Thank you.
Senator Bailey, Representative Matheson, and members of the committee. My name is Dr. Christine Monroe, DO, and I am an osteopathic physician practicing in Maine and chair of the Board of Osteopathic Licensure. I am testifying on behalf of the BOL in support of LD 2233. The BOL licenses and regulates osteopathic physicians and physician associates in Maine. BOL is composed of 11 members, 6 physicians who actively practice medicine, 2 physician associates who actively render medical services, and 3 public members. BOL's primary mission is to protect the public health and welfare of Maine by ensuring that those who are licensed to practice medicine or render medical services are ethical, professional, and competent. It fulfills this mission by licensing, regulating, and educating physicians and physician associates. Another medical board, the Board of Licensure in Medicine, BOLM, is composed of the same number of members with the same mission, but doing so regarding allopathic physicians. Approximately 18 months ago, members of the BOL and BOLM met to discuss the possibility of merging into a single board. Those meetings led to the introduction of LD 805, a resolve to direct the Board of Licensure in Medicine and the Board of Osteopathic Licensure to conduct a study regarding the feasibility of combining those boards. As representatives of the boards have already formed a work group and started regular meetings in January 25, the committee voted ought not to pass on LD 805 and sent a letter to the boards instructing them to continue their work and report back in January 2026. And that's just what we did. The joint merger work group met once a month beginning in January 2025, culminating in the boards voting to recommend the merger in a report to this committee in January 2026. The recommendation to merge the boards and the extensive and detailed report filed with this committee was the result of many hours of hard work, research, guidance, and input from the stakeholders, to include the Maine Osteopathic Association and the American Osteopathic Association. The BOL did not enter into this merger study lightly, and the merger of the boards was not a foregone conclusion. Indeed, the BOL approached this possible merger with an open mind, but with concerns about the possible loss of autonomy, independence, and identity. That is why one of the key components of this merger is that a merged board would need to be composed of an equal number of osteopathic and allopathic physicians, which is what LD 2233 creates. In addition, as is outlined in the report to the committee, the BOL examined whether it could financially afford to remain independent and hire the necessary staff in order to support it in fulfilling its mission to protect the public. After examining this possibility, the BOL concluded that imposing exorbitant fees on its licensees in order to generate the funds necessary to hire adequate staff was not reasonable, and that the merger of the boards would leverage staff and resources of BOLM, which includes an executive director who is ultimately responsible for overseeing the program of a merged board. At present, BOL is the only osteopathic licensing board in the United States without an executive level director, which will be solved by LD 2233. In addition, with the merger, the BOL will have the resources that it needs to fulfill its mission to protect the public without having to overburden licensees with excessive licensing fees. Following all the merger work group meetings and multiple board discussions, the BOL voted unanimously to recommend the merger of the medical licensing boards in accordance with the provisions outlined in LD 2233. LD 2233 structures a merged board by combining the current membership of both BOL and BOLM to create a larger pool of individuals to accomplish the work of protecting the public. Today, osteopathic and allopathic physicians work side by side in all types of practice settings. It is time for osteopathic and allopathic physicians to work side by side on a merged board, the Maine Board of Medicine. To our osteopathic colleagues who fear the loss of autonomy and identity from this merger, the BOL is fully aware of those concerns and shares them, which is why the merged board is structured to provide for an equal number of osteopathic and allopathic physicians, creates committees to include osteopathic physicians who review complaints against osteopathic physicians, and does not change the criteria for licensing osteopathic physicians. The BOL heard your concerns and recognized them as valid. The BOL hopes that you will likewise hear and recognize that the merger of the boards is in the best interest of the public. Thank you for the opportunity to provide these comments regarding LD 2233. I would be happy to answer questions now or at the work session.
Thank you. Questions from committee members? I had a couple, but I want to make sure other committee members didn't know. Great. So you had indicated, thank you so much for your testimony. You had indicated that there are 3 public members in both boards. can you maybe for the work session, just clarify what the background is of those public members if you don't know now? I'm happy to have that at the work session.
Well, I mean, we have, let's see, we have a nurse, we have, are you referring to their? Yeah, we have a nurse, we have a lawyer, and we have a nurse and a lawyer.
Great. So that's on.
Yep.
Great.
Two of them are here.
Okay. And you had indicated that your board in Maine is the only one that doesn't have an executive director. And that by combining these two, you would have an executive level director that is already existing in
Yes.
Bolum.
Yep.
What is the background of that executive director?
That would
Are
be,
they, is that a medical doctor?
that would be Tim Terranova.
That's what I thought. Just wanted to confirm. And do you know if there are any other states that have combined these two boards?
Oh, yes, we actually have reached out to, I can't remember, was it Utah? I cannot remember. There was a state that had done so recently. And it was, as far as I know, it was a success.
Okay, great. Thank you very much.
Sure.
Appreciate your time.
Of course.
Are there additional people who'd like to testify in favor of this bill? Welcome.
Thank you, Representative Matheson and members of the committee. My name is Dennis Smith of Augusta, Maine, and I am a public member of the Board of Osteopathic Licensure. One of the ones that
Thank you.
Rachel just referred to. I'm the lawyer, not the lawyer nurse.
Good to know.
Prior to serving on the Board of Osteopathic Licensure, and I'm testifying in support of, as you know, LD 2233. Prior to serving on the Board of Osteopathic Licensure as a public member, I had both legal and administrative experience with occupational and professional licensing boards, and that would include medical licensure and regulation. I served as an assistant attorney general assigned to the Board of Licensure and Medicine for almost a decade, assisting with investigations, licensing, rulemaking, and statutory revisions. As an AAG, I provided legal support and legal advice to the board concerning all issues affecting its licensing and regulation of allopathic physicians and physician associates. And following that tenure as an AAG, I served as the executive director to the Board of Licensure in Medicine, with the overall responsibility for the implementation of the board's various functions in protecting the public. And in that capacity, I learned about the staffing levels required to support the board and its mission, and the various aspects of its functions: licensing, complaints and investigations, rulemaking, the budget, etc. In other words, I know what resources that the Board of Licensure in Medicine has and how much those resources could help with a combined board. Now, as a public member of the Board of Osteopathic Licensure, which has a staff of one person, I can tell you that the merger of the boards will bring much needed support to the Board of Osteopathic Licensure. The Board of Osteopathic Licensure has a staff of one, Rachel MacArthur, who was just standing before you, who is very dedicated, but also very overwhelmed with all of the duties, and who performs all of the tasks of the Board of Licensure and Medicine's staff of 10. And you saw that in the report, I hope, that was prepared for the committee. Just imagine that load that she has. So I cannot overemphasize how badly needed those additional resources are for the protection of the public. For the past year and a half, I've worked with my colleagues on the Board of Osteopathic Licensure and the Board of Licensure in Medicine to study the feasibility of the boards merging. We have performed a great deal of work to include putting together a draft statute to make the structure of a merged board apparent and transparent. And LD 2233 is the product of that work. And while it marks the end of the separate boards, it ushers in a new combined board with equal numbers of osteopathic and allopathic physicians, together with their combined knowledge, experience, and differences. I want to close by sharing with you that I have a son who is an allopathic physician and a daughter who is an osteopathic physician. So as you might imagine, whether one is an allopathic physician or an osteopathic physician does not matter to me. Both are physicians who are working to help people. One is not better than the other, nor less than the other. And in my eyes, they are equal and always will be. So thank you for the opportunity to provide these comments regarding LD 2233, and I would be happy to answer any questions now or at the work session.
Thank you for your testimony. Questions from committee members? Seeing none, we obviously know that your daughter is your favorite. Just kidding. I'm just kidding. I actually do have one
I leave
question.
that to them.
I have one question. Thank you so much for your input and your service. So we're combining both boards. So we're having, instead of 11 on one board, we're having 22 on this new board. With all your extensive experience, what do you think about that number?
Well, I think it's going to allow the board to have more resources and to have committees to do the work that the current full boards do now. And so it'll be able to sort of farm out that function. And while still also being able to assign, an allopath to review allopath's case and osteopaths to review osteopathic cases. So I think it's a great idea to do that. And it separates the adjudicatory, investigatory functions as well. Although I do not share the concerns that about having not the same AAG for both of those committees, because those committee functions are going to be completely different. So I don't share that concern.
Great. Thank you very much. Appreciate it. Appreciate your testimony.
Thank you.
Are there additional people that would like to testify in favor of this bill? Welcome.
Hello, Representative Matheson and members of the Health Coverage Insurance and Financial Services Committee. I am Valerie Hunt, Assistant Executive Director of the Maine Board of Licensure in Medicine. I am here today to read testimony on behalf of BOLM's Board Chair, Dr. Renee Fay LeBlanc. She was supposed to be online. I don't know if there's a way to check to see if she's waiting before I read her testimony.
And I think we just have those that are, do we have anybody in favor of?
No, I don't.
Okay. No.
Perfect. Okay.
Thank you.
I have served on the BOLM, I'm going to move this. I have served on the BOLM since 2020 and have been acting as chair since July 2025. For the last 18 months, I have been involved in the work group discussing the merger between BOLM and BOL. I offer this testimony as an individual physician, not on behalf of the BOLM board. The mission of both BOLM and BOL is to protect the health and welfare of the people of Maine by ensuring that those who are licensed to practice medicine or render medical services are ethical, professional, and competent. The boards fulfill their missions through licensing, regulating, and educating physicians and physician associates. It has been an honor to work with the members of BOLM and supporting staff through the work group. Meeting monthly, we have discussed what a board merger might look like and have listened to feedback from the public. Through this work, we have drafted a written report and draft statute, which was presented to you in January. These documents come after much discussion, some healthy disagreements, and ultimately a way forward as one united board. As a member of the work group, I feel we have developed a proposal that not only protects the public, but allows increased collaboration between osteopathic and allopathic physicians and better utilizes available staff resources. The work is not finished, and the work group has continued to meet and discuss plans in case this legislation passes. I look forward to continuing to be part of this important process, and thank you for the opportunity to provide these comments regarding LD 2233.
Thank you. Questions from committee members? Seeing none, thank you for your
Thank you.
testimony. Are there additional people that like to testify in favor of this bill? Is there anybody in the room that'd like to testify in opposition to this bill? So we have people online. We have Bruce Wolf. Welcome.
Thank you very much. Good afternoon, Representative Matheson and members of the committee. My name is Bruce Wolf. I'm an osteopathic physician from Michigan and representing the American Osteopathic Association Board of Trustees as one of the senior board members. And the American Osteopathic Association appreciates the opportunity to testify before the committee regarding our opposition to LD 2233, which would combine the Board of Licensure in Medicine, which regulates the MDs, and the Board of Osteopathic Licensure, which regulates the DOs, into the new Maine Board of Medicine. First, while the education and training that the osteopathic physicians or DOs complete is similar to that which MDs complete, DOs additionally receive several hundred hours of specialized training in osteopathic principles and practice, including osteopathic manipulative treatment. OMT is a hands-on approach to diagnosing and treating patients that promote the body's innate ability to heal itself. OMT has been shown to provide effective relief for a variety of complex conditions, including chronic low back pain, while reducing reliance on opioids and other pharmacologic interventions. This hands-on approach and whole person philosophy, focusing on body, mind, and spirit, underpins osteopathic medical education, practice, licensure assessment, and regulation under the current system in Maine. Second, the DO board, which has served the people of Maine for more than a century, has demonstrated consistent efficiency and fiscal self-sufficiency, operating entirely through licensure, fees, and fines without requiring state appropriations. Its thorough DO-led approach to reviewing applications and complaints ensures the highest standards of professional conduct and patient safety, and we are deeply concerned that merging the two boards would compromise the effective regulation of osteopathic medicine and harm patient care, particularly since BOLEM must spend significant amount of time and resources on international medical graduate issues. The BOLEM spends a significant amount of time each year relating to licensing IMGs, which is only likely to increase if the legislature passes LD 105, which would create an additional licensing model, allowing internationally trained physicians to practice without requiring any U.S. residency training. Since the only individuals eligible for licensure as DOs in the U.S. are graduates of U.S.-based colleges of osteopathic medicine, these challenges are unique to the MD licensing and irrelevant to DOs, yet a merged board would have to divert time and resources away from the osteopathic licensure and complaint adjudication to IMG issues, ultimately slowing services to the detriment of DOs and patients. Instead, the BOL should remain separate in order to focus its resources on its mission to protect the public by licensing qualified DOs and reviewing complaints, and position the state for responsiveness to projections for further physician shortages, particularly in rural and underserved areas in Maine, which are disproportionately served by DOs. Since the current DO board is financially self-sustaining and has received approval for an additional staff member who is yet to be hired, the AOA continues to advocate for a conservative approach that works to address any specific issues that the board may have, but avoids the potential unintended consequences of wholesale elimination of the boards. This approach acknowledges the differences in DOs and MDs training, tools, and philosophy, which many patients deliberately seek. There is an entire domain of standard of care in osteopathic medicine that does not exist in allopathic medicine, which is most appropriately regulated by a board comprised of other DOs. For these reasons, we join the Maine Osteopathic Association and the National Board of Osteopathic Medical Examiners in asking you to oppose LD 2233. And I thank you for your time.
Thank you, Mr. Wolf. Questions from committee members? Representative Mastracchio.
Thank you, Madam Chair. So, could you just tell me is it's the American Osteopathic Association that you're representing. Is there a Maine Osteopathic Association?
Yes, there is.
And they're going to be here as well to testify, I would imagine.
That
So
is-
can I just
That
ask
is my
you,
understanding.
is your professional association, do you have, I know that a lot, like I know that they have like policies that they are promoting, and is one of the, I'm really seriously curious if your osteopathic association is dedicated to promoting osteopathic medicine and keeping it in a separate place from allopathic medicine. Is that a tenet of what you do?
It's not as part of the American Osteopathic Association, we are a federation of states. And so our position is to advocate for our states to be maintained under their autonomy of their jurisdiction from a regulatory perspective in this instance.
So the answer is yes.
Yes.
Thank you.
Additional questions from committee members? Seeing none, thank you for your testimony.
Thank you.
We have Doug Murray.
Good afternoon. I'd like to thank the committee for your time. I do not want to take up undue amount of your time. Our NBOME is in opposition to the merger proposed by this bill for the reasons stated in our.
Excuse me, sir, could you just introduce yourself? Thank you.
Oh, I'm sorry. Yes, my name is Doug Murray. I'm the general counsel for the National Board of Osteopathic Medical Examiners. And I'm here today just to advise the committee that the NBOME has submitted a written opinion on this matter, and we are in opposition to the legislation for the reasons stated. I will not waste the committee's time by restating it. We have submitted that in written document to the committee, and we agree with the testimony of the American Osteopathic Association and the testimony that we expect that the Maine Osteopathic Association will provide. We feel that the economics, the finances of this merger have not been demonstrated, that will save the state of Maine additional funds, and it will actually cost additional funds to the state for this merger, and that the Board of Osteopathic Licensure operates independently now under its current financially without, and this will result also in the increase of osteopathic licensing fees for DOs from $350 a year to $700 a year. So it'll be a doubling of the fees for DOs as a result of this bill. So that is a significant change. So thank you for your time.
Thank you very much. Questions from committee members, Representative Mastracchio?
Thank you, Madam Chair. Well, he's gone.
Oh,
Guess he doesn't want to answer the question. Nope,
no, here he is.
He's back. Too quick. What did you say your name was again, Miss? I can't.
Doug Murray.
Okay, thank you. I just want to know since the purpose of licensing is to protect the public, can you tell me how you think this merger would hurt the public? I'm not talking about osteopathic physicians and, any other, I'm asking the purpose of the licensing board is to protect the public. How does this hurt the public?
I think I would not phrase the question that way. I would phrase it, how does this merger advance protecting the public? And I don't see that
that's not the question I asked. That really is not the question I asked.
Okay. Well, in terms of protecting the public, it will not advance protecting the public. And in fact, may make the board inefficient because as the gentleman from the AOA said, there will be a lot of IMGs applications being reviewed, and potentially there will be a delay in DO's applications being approved, or disciplinary matters being reviewed because of the increased workload that the combined board will need to handle. So, that is a potential risk to the public that this will not create efficiencies that I think is the work group is hoping.
Additional questions from committee members? Seeing none, thank you for your testimony. We have John. Welcome.
Good afternoon.
Good afternoon.
My name is John Gimple. I'm an osteopathic family physician and a former dean at University of New England. And while I am from away, I did spend some time in the state, and I'm very, very fond of the state of Maine. I'm the president and CEO of the National Board of Osteopathic Medical Examiners, the same organization that Mr. Murray works for. And I speak against the merging of these two boards. While I'm very encouraged by the fact that the work group labored over a year of discussing the two different professions, as well as a third profession here, the PAs. And but I am at the same time saddened by the testimony of both DO colleagues as well as public member colleagues of the board that describe osteopathic physicians as just equal to MDs or allopathic physicians. It's not unusual in our profession. There is some professional identity related concerns, but osteopathic medicine is a distinctive profession that takes care of patients with an entirely different philosophy of care. And it is served best, I believe, by states that recognize that in the licensure of osteopathic physicians. In fact, there's no surprise that 4 out of the top 6 states in the United States, representing about 33% of licensed DOs, practice in states where there are separate osteopathic medical boards. They're managed efficiently by the state. They're resourced appropriately to be able to do their job. And clearly, there was a lot of attention to the fact that in Maine, perhaps the resourcing and management of licensing of DOs wasn't fair, certainly wasn't equal to what was being done by MDs. To choose a strategy that says, well, we'll just merge the board in with the board that licenses MDs, because after all, they're equal, is misguided by the true vision of what osteopathic medicine brings to healthcare. I'm encouraged by the fact that the proposed legislation does make sure that every DO have to demonstrate their competencies for osteopathic medical practice, just like an MD takes an MD licensing exam for that. But as Mr. Murray said, and I won't repeat more than a minute on this, all of the burdens that currently exist, that in the work group's testimony by Mr. Terranova talked about all of the burdens of internationally trained physicians that are adding more and more time and more resources to the work that the Maine medical board needs to be doing, are now going to encumber the work by the osteopathic medical profession and you in protecting the public by providing licenses, reviewing licenses, and dealing with professional discipline matters for osteopathic physicians.
Would you finish up, please, Mr. Gempel? Thank you.
Appreciate the opportunity to say hello and to provide that testimony. Thank you very much for the service that you all provide, and we wish you well. Thank you so much.
Thank you for your testimony. Are there questions from committee members? Seeing none, thank you very much. Appreciate your testimony.
Thank
you. Edna is the next person, Teresa. Okay. Yeah, those two are all gone.
Hello, can you hear me all?
We can hear you. We can't see you. If you might have a video that you can turn on.
Oh, okay. I will try, but I'm not going to waste time with that.
Okay.
So sorry that it's doing this. Okay, let me just see real quick. Join a meeting. Oh, geez. It says join and leave. I don't want to do that. Okay, I'm just going to speak if that is okay.
That's fine. No problem, Teresa.
Don't think
Go right
you need
ahead.
to. All right, thank you so much. So, good afternoon, Representative Matheson and distinguished members of this committee. My name is Dr. Teresa Hupka. I'm an osteopathic physician who practices obstetrics and gynecology, and I serve in the role of immediate past president and treasurer of the American Osteopathic Association. I'm speaking on behalf of the AOA and myself in particular. I would say that I echo what Dr. Gempel and what Doug Murray and what Dr. Bruce Wolf stated. And AOA has submitted their testimony in opposition to LD 2233. So we appreciate the opportunity to testify, but just in brief and in quick, I want to say that it shows that already the Maine Osteopathic Board was able to do quite a bit of looking at, and you asked the question about protecting the public. I think that that's what all boards do. That is what NBOME is about. And it's about making sure that physicians are appropriately trained and so forth in order to take care of the patients in the particular state. So one of the things that's pretty amazing is that this board has been functioning appropriately and serving those public members by making sure that the licensing and the board approval and so forth is appropriate for these physicians. They've been managed efficiently with a lack of resources, but they've done it as best they can. We do know that the board currently has been financially self-sustaining through the actual registration fees of the physicians and has received approval for an additional staff member who has not yet been hired. So we certainly want to make sure that, as Dr. Gempel and several of us have stated, that the unintended consequences of changing and eliminating the boards and bringing them into one would place a burden on the review process of osteopathic physicians and where they position themselves in the state. We are responsive, and we've been looking at physician shortages, and DOs, osteopathic physicians, disproportionately serve the underserved areas in Maine. And so if there is a focus on the international graduates, which that will burden certainly the BOLM, and we know that not only that they have to look at additional licensing pathways, allowing the internationally trained physicians to bypass U.S. residency training, which all of our osteopathic physicians are U.S.-based colleges. And so therefore, that type of licensing is irrelevant to us. And we do not think that merging the boards would help that. It would divert time away from osteopathic licensure. And we know that in Maine in particular, you will have a physician shortage. So again, what I would say is we are opposed to this, which would create a larger fiscal, not just fiscal, of an entity that is currently been functioning well, even without the proper resources, and yet resources have been allocated. So we think if you move forward with maintaining separate boards and allow them to have their proper resources, they will manage efficiently and do the work that they can so that we can keep the public served in those rural and underserved areas by osteopathic physicians. I thank you for my time to give you this information.
Thank you very much for your testimony, Representative Mastracchio.
Thank you, Madam Chair. Dr. Hubka, where are you? You didn't say where you were testifying from.
Oh, I apologize. So I'm in Illinois. So I practice in Illinois, and I'm speaking on behalf of, I'm the immediate past president of the American Osteopathic Association, but I'm also the treasurer. And I do find that, certainly, this board currently has been working fiscally sound with limited resources. And so I find that, again, our
Dr. Hubka, thanks. I don't want to interrupt you, but I have one more question.
problem.
I just want to ask you, you've been an osteopathic physician for a long time, I would imagine, since you're in your professional association and you hold a office in that. Can you just tell me if you think the average person really knows the difference between an osteopathic and allopathic physician when that physician is treating them?
Well, I would hope so, but I think so. I mean, when I say
I'm
that,
just-
I know that.
Fine. Okay, I get it. So you think that the average person really knows, they'll say Dr. Smith or Dr. You think that they do know the difference?
I believe that.
Generally. Okay, thank you.
Great, thank you very much. Additional questions from committee members? Seeing none, thank you very much for your testimony.
Thank you.
Is there anybody else online? No? Okay. Is there anybody in the room that would like to testify neither for nor against this bill? Thank you. I was wondering when you were coming. There she is.
Here I am. All right. All right. Good afternoon, Senator Bailey, Representative Matheson, and members of the Joint Standing Committee on Health Coverage Insurance and Financial Services. My name is Isabella Ascari, and I'm an osteopathic physician in the state of Maine who works in the emergency department. And I am here today to present on behalf of the Maine Osteopathic Association. I'm submitting this testimony neither for nor against LD 2233, an act to combine the Board of Licensure in Medicine and Board of Osteopathic Licensure into a single licensing board for all physicians and all physician associates. The Maine Osteopathic Association submits this testimony in a neutral, meaning neither for nor against, position on the proposed merger of Maine's two physician licensing boards. Our membership holds diverse and strongly felt viewpoints on this proposal. LD 2233 represents a significant paradigm shift as it relates to the licensure of osteopathic physicians in Maine who are accustomed to their own licensing board. Candidly, some welcome the simplicity of a singular board for the sake of efficiency. Others have heightened concerns. For that reason, we cannot offer outright support or opposition. We do, however, appreciate that the draft statutory language includes equal representation of DOs and MDs on the proposed unified board, a stated intention to preserve the identity and distinctiveness of the osteopathic medical practice and cooperative efforts between the existing boards to identify workable paths forward. Equal representation is critical, as many have said, as it acknowledges that osteopathic physicians bring a distinct philosophy of care, unique training and scope elements, particularly osteopathic manipulative medicine, that require informed peer oversight for the best regulation of practice and protection of the public. We feel strongly that equal representation must be permanently embedded in this statute and therefore appreciate the preamble and inclusion of actual numbers of DOs and MDs. Despite these improvements, the Maine Osteopathic Association cannot fully support the bill at this time due to several concerns. MOA followed the work of the merger work group closely, and despite our insistence to do so, we feel that it did not fully analyze the option of retaining two boards, despite evidence that many states operate separate MD and DO boards effectively, and our analysis that small improvements could have been made to optimize the current structure. The economic rationale for a singular board remains questionable, as the merger would require significant upfront expenditures without clear evidence of long-term savings, while the Board of Osteopathic Licensure has been self-sustaining and could easily be optimized. Matters unrelated to osteopathic practice, such as international medical graduate applications, could dilute the focus of osteopathic oversight. Even with equal representation, there's no statutory guarantee that osteopathic specific cases, particularly those involving the OMT, the manipulative practice, would be reviewed by DO peers first, raising the risk that complaints or competency evaluations could be handled by individuals unfamiliar with such osteopathic principles. The merged board would also oversee MDs, DOs, and physician associates, which could shift priorities away from osteopathic needs, especially given the relatively smaller number of DOs in the state. Almost finished. Because of the diverse views among members, however, the MOA cannot offer outright support or opposition as stated. We emphasize that equal representation of DOs and MDs is essential and non-negotiable, that economic and operational impacts require further scrutiny, that statutory protections must safeguard osteopathic philosophy, training, and practice in the interest of appropriately protecting Maine patients. Whew, almost done. We remain committed to working collaboratively with legislators, regulators, and our clinical colleagues to ensure that regulatory framework that maintains high standards of medical practice while respecting the unique contributions of osteopathic physicians. Thank you for considering this testimony. I am happy to consider answering questions, although I might not have all of the answers. And I'm sorry I went over time.
That's okay. Thank you very much for your testimony. Questions from committee members? Representative Boyer, don't go anywhere.
Thank you, Madam Chair. Thank you for being here. I had a question on where you're talking about you didn't feel that the small improvements could have been made to optimize the current structure. Did you have any thoughts that you can share on the fact that what we heard was they had one employee at BOL, and that was a significant hurdle. I know we heard in other testimony that there was opportunity to hire. I'm guessing that maybe there was a reason why someone wasn't hired, but would love your thoughts on that.
I might have to defer to the work group or to Charlie Sultan because I wasn't there at all of those meetings.
Okay, and that's fine for the work session as well.
Okay.
Thanks.
I had a question if no one else did. Great. Thank you so much for your, I have one for your testimony. So I'm very familiar with your your manipulative therapy, the OMT. Maybe for the work session, what in this bill would make you feel comfortable that this would be reviewed by DO peers first? And is there any other scope of practice that you were concerned about? My experience is that I love finding a DO that actually does this treatment, but I haven't really seen that very much in Maine. I don't know why, but that's my experience. So my question is, what would make you comfortable with that in this language?
I'm going to defer that as
Perfect.
well.
Thank you. Appreciate your testimony. Is there anybody else that would like to testify neither for nor against? You're all set. Thank you.
for physicians, there's a lot of really good handwriting up here.
We don't talk about lawyers.
No, you and I get a different thing, exactly. Senator Bailey, Representative Matheson, members of the committee. My name is Charlie Sultan. I am general counsel to the MOA and here neither for nor against. Dr. Scari gave you some good reasons why we are neither for nor against, but let me tell you some of the concerns that may address the questions you both ask. If you go to page 3 of the bill or 4 of the bill, you have 22 members of the new combined board, which is equal to the 11 members on each board currently. If you turn the page, you will see under quorum, lines 10 through 16, about what the quorum is for these meetings. A majority, again, page 5, lines 10. A quorum of the full board is a majority of the board, and that makes sense for any of you who have advised boards or been on boards. The next two, we have a deep concern about. It says that 5 members of the board constitute a quorum for the conduct of the adjudicatory hearings and 5 members under the investigative committee. If you turn then to page 23, it's top of page 23, talking about adjudicatory hearings. And this, it says that a subset of the other committee, and this is where the nomenclature, I think, of this bill is weird, talking about investigative committees that are both adjudicatory and investigative. But the adjudicatory committee is going to be a subset of the board members taken from among one of the 2 investigative committees. So that means it's not the other 11 members. It's some subset, less than 11. And then a minimum quorum of 5 members, or 5 members equals the quorum. Now, I've never been on board where a less than a majority of the full board is a quorum. So the way I read this, and we read this, is that 3 members out of the 22 can make a decision on an adjudicatory process. And that is, I think, a flaw in how this is structured. Now it says may, so that I think there's probably envisioning that it would, and we all thought going into this that the 2 would be split up, as it should be, because there's some case law about this. And I'll get to the AG part of that problem in a minute. That you really should have the other 11 being on the other adjudicatory panel and not some subset. It probably should be all. And then with the AG, since my time's is out, you have to have separate AGs for these 2 panels. And there's actually case law. So I was surprised by the comment that it was not a concern, because there is case law on this, where there were in the past on some of these regulatory boards, the same assistant attorney general being both on the investigative side, the adjudicatory side, and it was found by the courts to be a fatal flaw in that. So these are the kinds of details that we have concerns with. And to me as a lawyer, this is a big one, because it's also undermines what everyone's been saying about equal representation of the 2 physician professions. Potentially, those 5, you could have 1 doctor of either profession on them. So there's a structural flaw. It may be taken care of in rulemaking, but I think you need to take care of it to make sure that it is appropriately taken care of.
Great. Thank you, Mr. Sultan. Questions from committee members? Representative Foley.
Thank you, Madam Chair. Thank you, Charlie. Did you participate in the work sessions?
So certainly not all of them. There were members of both AOA and MOA that tried to participate in many of them.
I'm just.
I will leave it at that, only because we would reasonable people will disagree about how this process spun out.
I was just wondering if these issues were brought up during this process.
No.
Thank you.
Representative Mastracchio.
Thank you, Madam Chair. And Mr. Sultan, I mean, you've heard that the boards, both boards, voted unanimously to support this.
Yeah, there was a time when that almost blew up when, so.
I'm
but
just
yes,
saying
but
that
we-
they came here
we're-
after all that time and they came to agreement. And I guess for me, and why is it that you don't have the faith that these two boards have done all this work and that those are the kinds of issues that they will be able to deal with? Because, gee, color me surprised, but we're actually working together. Two groups that 15 years ago were not. So I'm kind of surprised, but maybe not, that the professional associations are the ones that are in here complaining about it and objecting to it. So I'm just surprised. Maybe I shouldn't be.
That was the question.
That is the question. I'm just asking, why is it, do you not think
Because
that
we,
that's
because the because the MOA represents a much larger group than the individuals that sit on the licensing boards.
Additional questions from committee members?
Thank
Seeing
you
none,
very
thank you
much.
for your testimony. Are there additional people in the room that would like to testify neither for nor against this bill? Seeing none, nobody online, right? Is there anybody else in the room that would like to testify in any capacity? Seeing none, do the members have questions or information they would like for the work session? Seeing none, thank you. Close the hearing.
Yes. Yes, whenever you're ready. Yep. Okay, so we will now open the work session on LD 378. And we've been giving the analysis, if you want to go through that, Colin.
Sure. Edna's handing it around on blue. This is LD 378. It originated as a concept draft. Senator Bailey shared an amendment to replace the concept draft, which was shared prior to the public hearing. It's also attached for you. It also should be in your folders on buff colored paper, but it's reproduced here on the analysis starting on page 3. It proposes to change the title of the legislation, and substantively, the sponsor's amendment seeks to further clarify a law that was enacted last session by the legislature, Public Law 2025, Chapter 487.
to clarify that statute to ensure that health insurers administering health plans on behalf of plan sponsors are considered administrators and must comply with the plan sponsor's statutory right to audit claims and data requests related to those audits. As noted, it seeks to clarify legislation that was considered by the committee last session, LD 1906. Attached for you, if you're interested, the legislative history related to LD 1906 on page 9. It was a unanimous ought to pass as amended committee amendment that was later enacted by the legislature. The sponsors amendment that was prepared for you shows the law that was enacted last session in its entirety. So I didn't include for you a separate copy of Public Law Chapter 487, but the changes in the sponsors amendment are shown to the full law. So I replicated the law so you would see the context of what was enacted previously and then what was proposed to be changed by LD 378. As I noted, the intent of the sponsors amendment is to make clear that a health insurance company acting as an administrator of a self-employed employer plan must comply with the requirements of Chapter 487 when plan sponsors make requests to audit claims data. Under current law, the definition of administrator, which was not amended in Public Law Chapter 487, excludes an insurer already licensed under Title 24A from the requirements for licensing and other requirements of Title 24A, Chapter 18. Because Public Law Chapter 487 allocated the substantive provisions related to statutory audit rights to Chapter 18, questions have arisen since the law was enacted about the applicability of the new requirements related to those audit rights for plan sponsors to health insurers that are acting as administrators of health plans on behalf of plan sponsors. So the sponsors amendment intends to add a new provision to clarify that an administrator includes any person who on behalf of a plan sponsor receives or collects charges, contributions, or premiums for, or adjusts or settles claims on residents of the state in connection with any type of health benefit, notwithstanding the language in the definition of administrator that appears to exempt health insurers that are acting as administrators. So the definition is included for you on page 11 of the analysis, and you can see there are two paragraphs in the definition of administrator that appear to exempt insurance companies and nonprofit hospital medical service organizations. Those were sort of Blue Cross and Blue Shield prior. They were regulated under Title 24A. So there's still authority for entities to be authorized under that title. So those two paragraphs are the ones that seem to be raising some concern because it defines administrator. And if you see at the end of that first paragraph of subsection 1, defines what an administrator is, someone who on behalf of a plan sponsor receives or collects charges, contributions, or premiums for, or adjusts or settles claims on residents of the state in connection with any type of life, annuity, health, workers' compensation, or employee benefit excess insurance benefit, other than any of the following. And those paragraphs provide those exceptions. And paragraphs D and E are the ones that have raised some concerns. So the bill itself, if you look at page 5 is one, the first example, adds a new subsection saying that for purposes of this provision only, these provisions only that relate to the statutory auditing rights, notwithstanding those two paragraphs, for purposes of this section, an administrator includes entities that who on behalf of a plan sponsor provide those administrative services in connection with any type of health benefit. So that's the sort of main substantive provision of LD 378. It makes those changes in two sections of the statute because there was one provision that applied specifically to sort of claims generally, and there was a second provision that applied to the chapter of Title 24A that relates specifically to pharmacy benefits managers and the administration of pharmacy claims.
I would note that during the public hearing, there were a number of stakeholders asking that the committee consider additional changes to the underlying substantive provisions that were enacted as part of Public Law, Chapter 487. Some of those suggested changes included considering a delay of the effective date to allow additional time for a stakeholder group to further study the issues presented in the bill and report back next session. Consider additional changes to further clarify the language used in the law, such as whether high-cost claims mean claims paid or billed. There were some other ambiguities that were raised that would benefit from further clarification about the terms used in the bill. There were also concerns raised about the timelines, the potential additional limits on the number of claims subject to audit, and additional language that would further protect the privacy and security of the data that might be shared as part of these, when these statutory audit rights were exercised. Last thing I would say is the bill has been drafted as an emergency, so if it moves forward, it would require a 2/3 vote unless the committee changed that. We don't have any fiscal information. I'll stop there and I'm happy to answer any questions that you have. There may have been some additional work and discussion among the stakeholders that I'm not privy to because I wasn't checking my emails, but I could see people going in and out of the room. So I'll let you get updated on that.
So first, any questions for Colleen on the analysis? Representative Olson?
Thank you, Madam Chair. Yeah, I get, you highlighted it that, there was a question in regards to the claim, $100,000 claim. Did we define that at all fully as far as where I'm looking at there is, suppose you have someone that's going to have a hip replacement. Okay. Is all the pre-work considered part of the same claim, or is that separate? The actual surgery is one claim, PT and everything else is a separate claim? Or how is that going to get bundled to determine whether that's $100,000 claim? And is that, you mentioned, and then the further is that billed or paid? Because your negotiated rate is certainly different than the billed rate.
Yeah, the statute that was enacted by the committee last session does define a high cost claim, but only really defines it in terms of the amount. And if you look at the statute in the first section, 1914 subsection 1, at the end of that subsection 1. So if you're looking on the blue sheet, it's on page 3. At the end of that subsection, it defines a high cost claim as any claim related to an individual provided health coverage by a plan sponsor that exceeds $100,000. So that's the only statutory sort of language that's there. And then it's up to the sponsor, to the plan sponsor to make the request to the entity for the audit rights, I guess. And then if you look further at subsection 1, it talks about the data that must be provided, must include any itemized billing statements and medical records associated with the claim in the possession of the administrator or the administrator's agent.
Maybe a better example is if you take a cancer treatment, a chemotherapy, is that one claim, or is the whole full treatment one? Because chemotherapy could be under the 100,000 limit, but the total treatment is above. So how is that going to be looked at? And if they want to audit, do they get to audit the whole total treatment or just that one particular operation?
I think that's one of the things that the committee could further clarify if you thought it needed further clarification. Otherwise, the statute envisions that it's information that's requested by the plan sponsor. There are also provisions in here that allow for these statutory audit rights, I guess, to be recognized as part of a contract. And so the contract between the parties could further define what these high cost claims would be. and how they would be calculated, whether it was claims paid, claims billed, or how they would treat sort of those situations or those conditions that you raised.
Okay, further questions? All right, and yes, I do understand that the parties have been having discussions. Mr. Panaki, if you want to come up and update us, and then we'll hear from the other side as well. That was my call. Anyway.
Thank you, everybody. If it's helpful to start with Representative Olson's questions about claims, I think we would be talking about individual claims. That's when we were originally discussing this bill with Community Health Options. They shared that it would be helpful instead of the episode of care, like you're talking about a cancer treatment where in aggregate they exceed $100,000. We're really just talking about specific claims, one claim that exceeds $100,000. We'd be talking about the allowed amount. So it's the combination of what the plan paid and the member paid for that claim. So I'm happy to add additional clarification along those lines. If it would be helpful.
I mean, I think we can clarify, but yeah, I think that's the way it reads. It's any claim related to an individual. So it sounds like a single claim to me.
Yeah, I think if you were to take multiple claims into an episode of care, you would have a lot more instances that exceed $100,000. And we're not looking for it to be too onerous here. Understand there are already concerns about the administrative lift of providing prepayment audits on high cost claimants. Otherwise, I've shared some language. There are a few last minute changes here, so I will try to walk you through them. Essentially, we did meet with Anthem and discuss several proposed changes. We could not get to agreement on all of them. I think some of them really fundamentally would have undermined the rights that this committee had unanimously passed in the last year. But we did work with them to try to clarify some of the language in the non-disclosure and data use agreement section, which is number 4. And it basically is meant to clarify that the carriers, plan administrators would be negotiating liability in their NDAs and DUAs with the plan sponsor and the auditor. So you can see the underlined language here basically includes all the changed language in here. You'll see I noted in red pen, or my colleague Lisa noted in red pen, the handwriting looks different, that I accidentally underlined the last sentence, agreement with the administrator or refuses to execute a non-disclosure. That actually is the same language that is in the underlying statute. It was also brought to my attention just now that in moving this over, there is a missing sentence that's not flagged that exists in the underlying bill, but we would recommend removing in the edit because it just becomes duplicative of the edit we made.
And where is that?
That is the sentence right in number 4. It's the second half of the first sentence, second line. So associate execute a non-disclosure and data use agreement that reasonably restricts the auditor's use of data provided by the administrator for the sole purpose of conducting an audit on behalf of a plan sponsor. So we added additional language, or we subbed in different language to say provided in accordance with the section to restrict the auditor's use of such data to the sole purpose of conducting an audit on behalf of the plan sponsor. So I'd be happy to work with Colleen to clarify that. I don't think it makes a substantive difference. It really was just for clarity's sake and an error in moving it over. So I'm still clearly not very good at that. We also added a new section under 4A, liability for disclosure of protected information, which basically outlines the sort of what qualifies as protected information. The personal information is defined in Title 10, Section 1347, subsection 6. PHI related to HIPAA, electronic protected health information is defined in the Federal Health Information Technology and Economic and Clinical Healthcare Act. And non-public information is defined in Section 24A. There are a couple changes that we just discussed that I would like to make to this. We have sections 10B and 10C under D. The non-public information is defined in Section 24. It says MRSA 2263-10B and C. We have agreed to include 10A as well in that. And we have also back up to that first paragraph under 4A where it says section shall be required to notify the administrator of any breach. We've agreed to add the words of any unpermitted disclosure or breach because there is a technical definition for breach that is less expansive. So it was brought to our attention that if an auditor accidentally posted a file of protected information to like a public website, that's not technically a breach because nobody breached that data. They just put it out there publicly accidentally. So we wanted to make sure that the carriers receive notification of that when it happens as well.
Okay. Any questions?
Oh, I would also note, we had made a change, just to really narrow it in, make it specific. We had changed business associate in number 4 to auditor. But it just was brought to my attention that that makes it a little bit inconsistent with language throughout the rest of the bill. So we're just going to go ahead and change that back to business associate at the request of Anthem.
Where is it? It's right here. Auditor used to be business associate. Okay. Thank you. So we're. Right. Representative Olson.
Thank you, Madam Chair. Who bears the responsibility for advising the consumer of breach or release of or improper release of information? Is it the administrator or is it the subcontractor?
That is a good question that I don't know the answer to. I would assume it is the administrator upon discovering a breach would have to notify affected members, but I'm not. It's
It would be both potentially, yeah.
There is a requirement under HIPAA and these are laws that there is a notification requirement that they're all subject to. So somebody, one of the parties, all of the parties would notify the member.
Okay. Further questions from Zone Maps? Thank you.
So section 4A-D, adding in 10A, B, and C. What does that mean?
So that just clarifies specific kinds of non-public information, really business information that's not public. So it's not personal health information, but it's
So
potentially
proprietary information for the
it could
business?
be like a business tax ID or things like that that are not necessarily, maybe that's not a good example.
Okay, thank you.
The definition under data security, insurance security, of non-public information. Okay, further questions? Representative Cole.
Yeah, Trevor, I was just curious, back when we had the original testimony, we've heard about the amount of time and the expense that it costs for the carriers to do this. Can you elaborate on if you know, is that a burden or is it a?
Yeah, absolutely. So my understanding there are large like jumbo national employers that have gotten these rights and are currently conducting audits on their claims. And my understanding is that it's not onerous, but we did include language here in the event that it incurs additional costs to the carrier to be able to facilitate these audits, that those costs may be passed along to the plan sponsor. And I think the key here is that this doesn't require employers, plan sponsors to audit. It just gives them the right to do it if it makes sense for them. So they would request an audit. A price tag would essentially be given to them from the carrier for facilitating that. And then they make the decision, is it worth it to me to pay this and continue with the audit? Or is it a too high a barrier and we're not going to do the audit? But we did try to make sure that the language said, reasonable, justifiable expenses, so that the cost that the carrier gives to the plan sponsor cannot be arbitrarily high, and just to dissuade an audit from taking place at all. But we do understand that there would be some additional work that would be required, and that the carriers deserve some compensation to cover that additional work.
Okay, further questions? Representative Harper.
Thank you, Madam Chair. I'm just curious about this fee. Would it be a negotiated fee? Who would determine what the fee is, if there was going to be a fee?
The insurance company, the carrier would determine what that fee is, but there is language to say like it's tied to their real costs to doing it. And my understanding is that that has actual legal value to it. So I believe it would be an appropriate cost. And I suppose that the plan sponsor could try to negotiate it, but really it's just meant to say there's a cost associated with this. We're going to pass this cost along, but it can't be an exorbitantly inflated cost that makes the audit prohibitive.
Okay, further questions? Seeing none,
Thank
thank you
you.
very much. Who would like to come up for the carrier side?
One who knows.
Okay. I didn't want to presume.
I won't stick Mr. Demerit or Mr. Sultan. In fact, I have to catch them up, actually.
We can catch them up at the same time you catch us up.
Right.
Okay.
Good afternoon, Senator Bailey, Representative Matheson, and members of the committee. I'm Chris Ossenfort with Anthem Blue Cross and Blue Shield. And as Mr. Putnaki noted, we have been discussing, and I think we have an agreement in concept with what he distributed. We keep looking at it and finding little errors or omissions. So we're happy to provide a cleaned up draft to your analyst after the work session. So we do think that this helps to address some of the concerns that we raised at the hearing with respect to the legislation that was passed last year. I think one thing that Mr. Putnaki forgot to mention is we talked about an effective date.
Yes.
I'll get it. Although it's emergency legislation, but we talked about an effective date of July 1 of this year, just so that there is a date certain as opposed to trying to track the moving target of when it gets through and signed. And I believe that they were agreeable to that. With respect to Representative Foley's question, we do remain concerned about the administrative burden associated with this. The burden is not completely alleviated by reimbursement for the expenses incurred. We are concerned, and I think Mr. Sultan testified to this, about the potential impact of several customers requesting all their claims, in a close period of time and having to respond within the designated timeframes. We did suggest perhaps a tiered approach to Mr. Putnaki that just as an example, you audit 200 claims, and if the error rate is above a certain threshold, you get to audit 200 more, because the concern expressed with respect to LD 1906 last year was that they were artificially limited to a small number of claims. So we suggested sort of if the results aren't good, you get to audit more, and if the results still aren't good, you get to audit more. They did not find that approach acceptable, but we do think that is something that could be considered to reduce the administrative burden.
Representative Matheson.
I love that you brought that up on Mike, because there, as a provider who gets requests from Anthem,
We get an audit, you get it.
I'd love there to be a tiered time frame. So if you're amenable to talking that.
They're not
way.
amenable to. But it does, there may be times when we need to go back to the providers to request information to comply with an audit.
Trust me.
Yeah.
Representative Olson.
Because these are self-insured and whatnot, do you have the same MLR requirements as you do under the individuals? So in other words, if if you have to, if there's additional administrative burden, even though it's reimbursed, it still goes in as an administrative cost, and is that hit against the MLR?
So there is no MLR with self-funded plans because there's really sort of two buckets. They pay the claims. We don't, I mean, we process the claims, but they are paid with the customer's money, the plan sponsor or the employer's money. We are reimbursed solely based on for administrative services. So there is no MLR calculation because it's sort of two buckets of funding. We don't get any percentage or of the claims. We just get basically a per member per month administrative fee. Does that answer your question or further questions? Representative Foley.
Yeah, Chris, I'm concerned about what you mentioned. If, let's say, Anthem got a request from 3 different entities a year, all at the same time, and they all want 200 claims, that would be probably impossible to accomplish within 2 days.
So there's different timeframes.
And that's what I was trying to look in here.
I think it's 30 days that we have to respond. Right. So there's 2 different categories of review under the existing legislation. One is the high cost claim, which is a prepayment review. So the plan sponsor gets notified that there's been a high cost claim. They tell us we want to review that, and they have to request that within 2 business days, and then we have 30 days to provide them with the information they've requested. The other is the audit of all claims. And that's where we're concerned about the administrative burdens, because to your point, Representative, you're concerned if we get a request for 200, we're concerned about if we get a request for 100,000. And so that's why we suggested the staged approach of 200. But I don't know if that answers your.
Yeah, I'm just trying to figure out how.
If you, on page 3, where the statute is, if you look at it's subsection 1 and subsection 2, but the post audit that Ms. Ossenfort was referring to, that governs that. It requires, you can allow someone to request a post-payment audit with the contract at least once in a calendar year, as long as the request is not earlier than 6 months following a previously requested audit. And then the time frame is upon request, the administrator shall disclose within 30 days. Once they've certified compliance with the data and use, and then it lays out the additional requirements on page 1.
Other questions? So I can't believe I'm saying this, and even though I'm saying it on mic, I'm going to deny ever saying it. But it sounds to me like it might be a good use for AI.
I'll deny it. We'll have to make sure that's protected going forward.
Don't go that far. All right, thank you. Further discussions, questions? Representative Chimino.
I was just wondering, I don't know if, no. Your mic, sorry. Thank you, Madam Chair. I don't know if Trevor would be able to say, but why was it that it was opposed, the tiered approach?
Okay, come on up.
The tiered approach that was suggested was 200 claims, and if the error rate is above 10%, then you would get another 200 claims, and if the error rate is still above 200%, you would get another 10%, another 200 claims, and so on and so forth. We have members that are processing 500, 600,000 claims a year. So if you take a plan like the Maine Municipal Plan and you do them in batches of 200 claims at a time, you'd have to be doing 6.8 audits per day for the entire year, 7 days a week for the entire year. That to me seems far more onerous than pulling one claims file that you're sending on to an auditor within 30 days. I understand that it takes more time than that to work through processing those claims, analyzing those claims, validating the findings in those claims. But what happens is that when you find errors in claims, it's rarely a specific error to one claim. It's often a systemic issue where you don't need to go in and fix one claim at a time. You go in, you find the error, you fix the whole bucket of claims that are impacted by that error, which I think eases a lot of the administrative burden. And frankly, it really, for our members, just comes down to the fact that they have a fiduciary duty to prudently manage their plan assets, and auditing 200 claims is looking at, again, a fraction of a % of the total claims paid in a given year. They want insight into all of those claims. And so they believe they should have the right to audit all of them.
Further questions?
Thank you.
Thank you. Discussions. I'll make a motion ought to pass as amended as outlined by both of them.
I'll
Yeah.
second that.
Seconded by Representative Matheson. Further discussion. Did you need to
They
caucus?
needed to caucus.
Okay. All right. Thank you. Oh, Representative Olson.
I'm just wondering if, because we're kind of breaking to some degree some new grounds here, whether we should build in some kind of a report back in some place to see if we need to do any down road tweaking.
Who would report back?
That's the question. Who, but I mean,
Because we don't even know.
Yeah, but it's one of those that, I mean, if it's working fine, then, but I mean, I guess it would come back to us at that point if someone would request legislation anyway. It's just.
I think
I'm
if
just
there are
looking at-
problems, yeah, people.
I'm just looking at it from the standpoint of where there may be unknowns that we're not thinking about. And, just like the fact that, we thought we were good, and then all of a sudden we found out we weren't good. And what are we going to find once it goes into practice too? And
Yeah. I'm confident that people sitting in this room will bring it to our attention. One side or the other, or both. Further discussion. Representative Olson, you turn your mic off.
sorry.
All right, I think we're ready to vote, Edna.
So we'll get to see the language reviews of.
Yes. Yes.
And the motion was, I'm sorry,
Ought to pass as amended.
Senator Bailey.
Yes.
Senator Bailey, yes. Representative Matheson.
Yes.
Representative Matheson, yes. Representative Arford.
Yes.
Representative Arford, yes. Representative Boyer.
Yes.
Representative Boyer, yes. Representative Shamino.
Yes.
Representative Shamino, yes. Representative Clucci.
Yes.
Representative Clucci, yes. Representative Flynn.
Yes.
Representative Flynn, yes. Representative Foley.
Yes.
Representative Foley, yes. Representative Mastracchio.
Yes.
Representative Mastracchio, yes. Representative Morris.
Yes.
Representative Morris, yes. Representative Olson.
Yes.
Representative Olson, yes. 11 members of the committee have been voted in the affirmative and 0 in the negative.
Right. Thank you. That'll close the work session on LD 378. And now we have some language review, I believe, Colleen. It's fine.
This is what I was thinking. Edna's gonna hand out these four. I didn't know if you would still have it. This is this is 221, which we never got to. If you want to do that too, but whatever, what do you want to do?
Yeah. So you have 2201 separately.
In your folder.
Oh.
Okay.
Recent, it's
Can we
not
do
me.
it first?
Oh, got it.
That was.
I think we'll do 2201. That's the folder on top of my pile at least, so. Where it is, everyone else's. I know. It's stressing me out, but we can do it. But it was the top of the pile.
So 2201, yeah. So committee had voted on this bill, and following the committee's vote, prior to the language review, Representative Boyer asked that I share a revised amendment, sort of making some additional changes to what the committee had voted on. So that's what you'll see on pink. So you'd previously looked at a version of this, and then this pink is an updated version. The committee hasn't yet discussed this, whether or not you wanted to make the additional changes that Representative Boyer has suggested for the committee's consideration. And some of those, I think, were raised during the committee's public hearing and work session process, but then were also raised after the committee's vote. And so some of these changes seek to incorporate some of those suggestions. So the pink does sort of three additional things, and I'm happy to go through it, but just to highlight for you where the changes are. One is in the definition of private equity company. It updates that definition to be consistent with definitions that used in similar laws in other states. It also provides an exemption for independent provider practices with 6 providers or less that experience a material change transaction from the review process. You might recall that the reporting piece had an exemption that the committee voted on for independent provider practices. So if you look at the language, just so you can see where that language is, at the top of page 10, the double underlined language are sort of the new suggested changes from Representative Boyer. So that's how you can track where the language reflects the committee's initial vote, how to pass as amended on this bill. And then if you see bold italicized language that's double underlined, that's would be the additional language that Representative Boyer has suggested for the committee. And you'll see here it proposes to add an exemption saying that the section, so the requirement to undergo a review of a material change transaction would not apply to an independent provider organization without any ownership or control entities consisting of 6 or fewer physicians. I think it should say providers, and that's my error, that experience a material change transaction. And then finally, in the reporting section, which is section 2 of the committee's amendment, starting on page 10, Representative Boyer had suggested some additional changes to the reporting requirements, and primarily proposing to remove some of the reporting requirements, and you'll see those with double strike through. So this draft is proposing to strike paragraph F, which would have required reporting of the name, business address, business identification numbers, federal tax classifications for each person or entity with respect to a relevant healthcare entity has an ownership or investment interest, has a controlling interest, is a management services organization, or is a significant equity investor. In paragraph G, it makes some changes to the organizational chart that would be required to be provided to state that it would be a current organizational chart showing the business structure of the healthcare entity, including affiliates and subsidiaries. It would, in paragraph H, where information would be required to be reported about affiliated healthcare providers and affiliated healthcare facilities, that would be limited to just hospitals. And it would propose striking paragraphs I and J. Paragraph I related to the reporting of names, national provider identifiers, and compensation of members of the governing board or board of directors or similar governance body for a healthcare entity, any entity owned or controlled by, affiliated with, or under common control with the healthcare entity, and any entity described in paragraph F. That's been stricken. And then paragraph J is reporting of payer mix information. So that was, I think, sort of highlights the additional changes to the prior version of the amendment that the committee had seen, that Representative Boyer was suggesting the committee consider including. I'll stop.
Questions, Representative Olson.
From a consistency standpoint, on page 12, section 3, you've got physician in there instead of provider.
Yeah, I was going to bring that
Same
up
thing,
too.
yeah.
Yeah, and I think we had actually
Yeah.
said specifically providers there, so. Yeah. Thank you. People are paying attention. I
Thank
like
you.
it. Yeah.
Appreciate that.
Representative Cooch.
So do we need a motion to reconsider so that we can?
Yeah, if I just wanted people's questions to be answered first, if they have
Oh,
any. just
okay,
to
'cause I have-
clarify.
I have questions, but they're not necessarily clarifying questions that about what Colleen just presented. So, but I will have questions for Colleen about the bill when we move into work session, I guess.
Okay, Representative Boyer.
Thank you, Madam Chair. Colleen, I had a question on page 5D. You had added this to ensure it's like, projects, material change transactions would go one route. Certificate of need or this route. And I just wanted to, I had someone reach out to me and indicate they didn't think that language was clear. Do you feel like that is clear, or we don't need to sort of make that any different?
My understanding was that you're not replacing CON, that they would be
Right.
run parallel to each other, which I think is what this language does. But what you just said was they would do one or the other, which is not what I thought the committee intended. So if you want it to be one or the other, I think you'd have to clarify that more. My understanding was that it was not, they were complementing each other, if you will.
Right.
Not replacing.
Yeah,
you
one
weren't
is sort of a
replacing, which I
complement.
think is what this language does. But if you wanted them either or, I think I'd have to clarify the language further.
Wasn't my intention. Yeah. Representative Cooch.
So does that mean if somebody wanted to buy an existing hospital, if private equity wanted to buy an existing hospital, they would have to go through this certificate of need process as well as this new process?
Potentially, if it qualified as a material change transaction and if it met the standards. And this process sets up sort of a preliminary review, which isn't as intensive as a comprehensive review. And there's some parameters for what qualifies for comprehensive review and what can be subject to preliminary review. But yes, under the existing CON requirements, there is a requirement that if there is a transfer of ownership or control, that's one of the requirements or subject to a CON, triggers a notice to the department. And so that would stay in place, I think. And this would also be in place and they would be complementary or run concurrently if
A lot of the
they were subject
information
to. Yeah.
needing to be provided is going to be, there's going to be a lot of overlap. Not exclusively, I'm not saying that, but it's not.
Yes, but I thought that was the intent, but
That was my intent.
But-
Yeah, Representative Boyer.
And they're both going to the department, like either process is through the department.
yes, yes.
Whether it's
Either
certificate of
process
need
is
or
through the
this
department.
material
What
change
what
transaction.
LD 2201 will do is require a more formal role and involvement of the Office of Affordable Healthcare in sort of doing the specific elements that would be required here, allowing the department to consult with OAHC, and OAHC would provide their expertise and assist if the department requested their assistance in sort of evaluating the material change transaction, particularly related to the cost and impact on the market. And sort of, if you look particularly at the comprehensive review process language, which starts on page 5, that's where it sort of lays out in paragraph B, kind of the involvement of OAHC, which is not a part of the COM process.
Oh, makes sense. Yep. Representative Arford. Thank you, Madam Chair. On page 2, the private equity company definition, which was one of the things you drew our attention to because it has changes. The original, I don't have the original copy. So in the original copy, where did the definition end? Did it include all of that, or is this other than the part you've crossed out? Was
That was the
original
original
Okay,
definition.
so the whole thing.
Yep.
Okay. And then when you said this is one of the reasons for making this change is because this definition is being used by a number of other states. Do you have any information on how many other states or?
I don't know how many. It's primarily based on the Massachusetts definition.
Okay, so the Massachusetts, and then I have one other question, and that's about, I think it's on page 10. At the very bottom of page 10, the names of the members of the governing board or board of, if you could, should I save this question for after we reconsider? No, go ahead. Okay. I just would like some clarity on why we would not want to why we would want to edit, why we'd want to remove that requirement.
That's a policy decision. I think Representative Boyer can speak to that, but that was a suggestion made by some of the stakeholders that paragraph, that reporting should be removed.
I'm sorry, where are you?
On page 11?
Paragraph I.
Yeah.
Yeah, this was just basically trying to find a compromise with stakeholders is why that was removed.
Okay. And that doesn't, if it's I'm a little bit confused with the for-profit and the nonprofit status, this doesn't, this doesn't have anything to do with that. That's simply just saying we're not going to publicly report any information on the members of the governing board or board of directors. Is that what that's saying?
Correct. That was removed. So that would no longer be required to be reported.
Okay. Okay, great. Thank you.
There are some other ways that information. There are some other ways that information might be publicly reported specifically for hospitals, but this wouldn't be required to be reported to MHDO as part of these requirements.
Okay. Further questions, Representative Poland.
Thank you, Madam Chair. Yeah, I have a couple of concerns or questions. On page 10, when we're talking about number 2, reporting ownership and control of healthcare entities. Let's say that I'm a physician in a practice of 20 physicians. Or let's say I'm Intermet and I bring in a doctor and they work for 3 years and we make them a partner. Now that's a material change in ownership. So does that mean because we make a doctor a partner that they have to report the fact that we made doctor a partner?
I don't think that's a material change because if
What's a
you look
material
at the
change in ownership?
definition of material change transaction, it's the acquisition of a majority interest or operational control of a healthcare entity occurring during a single transaction or in a series of transactions by a private equity company, hedge fund, or management services organization. And then organizational control is operational control, excuse me, is also defined. And that's where the control is of a healthcare entity is obtained by a private equity company, hedge fund, or management services organizations. So my reading about when they would have to report on a material change transaction, it wouldn't be triggered by that situation. But as we discussed, there is an element in this reporting of kind of a one-time baseline report of ownership and control of entities. And then subsequent reporting would be only triggered if there was a material change. So there might be some initial reporting that Intermed or practices would be required to make. And then subsequently, as I read this, the reporting would only be triggered when a material change transaction occurred, and that would have to require the involvement, as these terms are defined, of a private equity company, hedge fund, or management service organization taking a majority ownership interest or operational control of that healthcare entity.
So under this number 2, this becomes public information. This is stuff that,
Reporting section 2.
right.
So the public part of it is in subsection 4. And related to transparency. So it could be public information, but then there's a second piece, paragraph B, is the reporting of MHDO that's reporting prior to, and there should be, this is my oversight, but I will have to make some additional, I forgot to mention it, additional changes to paragraph B to reflect the changes if you take out some of the reporting information. Just to be consistent, those paragraphs F, G, H, I, and J, to the extent that they might be referred to in paragraph B, they'll no longer be disclosed. So I just need to make those clarifying changes, but it would make the information publicly reported by MHDO and posted on their website. Be the name of healthcare entities that reported for the previous 1-year period, disaggregated by the business structure of each entity, be the name, address, and ownership or controlling interest. So who controls that interest? If there's been a change in ownership or control, the tax ID number, I think, would come out, based on, I'd have to go back and look at that. And then under subparagraph 5, some of that specific information about affiliates and disclosure that would now be limited to just related to hospitals. So I'd have to make some clarifying changes that I neglected to do if you go forward with what Representative Boyer has suggested.
Yep.
My concern is on page 11 at the top, where we're reporting taxpayer ID numbers, national provider ID numbers, employee identification. Those should not become public information. And that's why as I'm reading, it says reporting. And I just want to make sure that if we're asking for this information, we're not putting that out in the public domain. It should not be. I mean, taxpayer ID numbers should not be disclosed.
I mean,
The only protection is it provides confidentiality protection to the extent that it's someone's social security number under this draft, and under the original bill, that can remain confidential. But if you wanted to make some additional changes, we can make some additional clarifications. There are some existing confidentiality provisions that MHDO has that may not be broad enough to encompass that. So if you wanted to protect the specific taxpayer identification numbers from being made public, I think you would expand paragraph A to include not just taxpayer IDs that are social security numbers are confidential. You would provide confidentiality for
I mean, I
all of
think
them.
all 4 of those items that are on top of page 11
Yeah.
would be problematic.
You could, yep.
Public domain. And so I think however we have to do that, I think we should
Yep, you
figure
could
out how
add
to
that.
make sure that that's
rooms and maps.
NPIs are public domain, but just FYI, the national provider identifiers are public domain information. My NPI is public information, so you could look me up, just NPI, Christy Matheson, and you'd get that online.
But the other information
Yeah.
is not. So, I mean, you can leave that, I don't.
Yeah.
I saw all four of those together and I'm thinking some of it's problematic.
Makes sense.
Can I continue?
Yeah, go ahead. It's a work session.
I really still have a problem with the assessment piece. Where we're going after healthcare companies, health insurers, for,
We didn't. Oh, it's a language. Yeah.
on page 9-6. I mean, it seems to me that
Oh, we took that out.
we're trying to make some money for the organization, but I don't know why we would be going after health insurers, health maintenance organizations. I mean, and I've had a discussion with the Insurance Bureau on, I mean, this would be between $4,000 and $6,000 per entity. And I don't know how many entities we have, but you're talking big, large, small. It's talking what their premiums are, but I just don't see why. I mean, it seems like whenever we need money someplace, we're going after the health insurers. And if we do that, it goes right to the ratepayers. That's who's going to pay this. And we always are concerned about the insurance premiums people are paying, and we just keep piling it on. So I mean, in this bill, we have a provision where if we're doing a review of an entity, we can charge them for that. I mean, there's a way to get the money for paying to do that. You know, I just don't know if we're trying to create a slush fund. Again, the assessment part concerns me that especially where we're going after health insurers. So I don't know what we can do or want to do about that. I just want to raise it as a concern that I have. And again, I just don't want us to continue to go after health insurers for, I mean, some of the health insurers that this would hit aren't financially as well off as others. And we don't certainly need to keep hitting them up. And the last thing, I still have a problem with private dental practices. Privately owned dental practices cannot be owned by anybody other than a dentist. And this, when we in the commission, and that's not who we were going after. I mean, that wasn't part of our discussion at all. And so, I mean, I would love to see us, the healthcare entity, and as we exempt nursing facilities, exempt privately owned dental practices with some sort of definition, because that's not something that we were interested in going after. But that's my 3.
Yeah, no, thank you. And I thought we had removed the assessment for carriers, but I might be misremembering. Representative Boyer, did you have?
We had not, and respectfully, Rep. Foley, it's certainly not to create a slush fund. I'll just remind committee members that certificate of need is 1 full-time employee. So what we're asking the department to do is do something else. And so we have to be able to give them resources. We can disagree about where that should come from, but it's certainly not to create a slush fund. The assessment is 1/5,000th of 1%. So we hadn't talked about removing that. I know there are some concerns about that. We certainly can. The only other thing I'll say about this is, you know, if we don't have this assessment, it's going to go to the table. So we just need to be mindful of that.
Right, but there are 2 parts. There's the filing fee, which, I mean, I think all people agree there should be some sort of filing fee.
I think there is
So-
a file.
Right, there's two
Yeah.
pieces, but then the second is the assessment against
Yeah, I don't have a
barriers.
problem with the filing fee.
Yeah,
Okay.
so I mean, it would stand to reason though, if we remove the assessment, we're going to increase the filing fee. And then in my humble opinion, you're just going to have a different group of stakeholders who's upset about that.
Okay. Representative Clucci.
Thank you, Madam Chair. So I have a couple of questions. One, I also agree. I don't think that the health plan should be paying the into the assessment fund. I'd much rather see the assessment fee go up. And then
You mean the filing?
I'm sorry, the filing fee. Yeah. Yeah, okay. And then on page 12, at the very bottom of page 12, part 4C, it talks about, the organization can share information with the Office of Affordable Healthcare, the AG, and other state agencies to reduce or avoid duplication and reporting requirements. So I'm wondering, Colleen, do you know, there's a lot of information, I think, of some of this list entity ownership that would go to the Secretary of State's office every year with the annual report filing. Is that?
No.
The way this is drafted, this is just allowing MHDO to share information with other entities.
So it's not about actually reducing the duplication of entities needing to submit like all the same information to multiple state agencies?
Not necessarily, but it would have to be, I mean, it would be someone requesting it from MHDO, and MHDO would be authorized to share it if they wanted to. But it doesn't change those underlying sort of statutory requirements that might be there to file. You know what I mean? There's no corresponding removal of those statutory requirements by this legislation. So this could offer an opportunity for someone to access information that they might need through MHGO if they thought they could, but it doesn't make a corresponding change if someone's obligated to file certain information from the Secretary of State. It doesn't amend that section of statute to say you don't have to do it anymore if they can get it from MHGO. Does that make
No,
sense?
yeah, I was just thinking it was putting in here that there would be making some attempt to try and streamline the amount of information that's required from the state. But that's not how this is written. And so that's my misunderstanding.
Yeah, I think it's
Okay.
written in a way to say that, instead of asking for the information potentially that they might have the authority to get directly from the entity, they could ask for it and get it in another way. Because there are some provisions in here that allow the department or OAHC to request additional information from entities. And if they could get it in this way, then I think it recognizes that. And allows the sharing of information between state agencies in a way that will maintain confidentiality if they're sharing confidentiality information. I view it more as authorizing that, but also making clear that if you're going to do it, it needs to be done in the confidential, to maintain the confidentiality of the information. Can't be sort of distributed further or made public if MHGO is going to share it.
Representative Chimino.
Thank you, Madam Chair. Getting back to that, that filing fee, how much is that filing fee? And what is it based on?
So I don't know particularly what it's based on, but it allows the language of the legislation on page 9 authorizes the department actually requires the department to adopt rules setting minimum and maximum filing fees. And it says the initial filing fees may not be less than $1,000 nor more than $5,000. So the specifics could be established in the rule, but it sets sort of the range. It also requires, initial kind of filing fees, and then the department is also directed to adopt rules to establish fees to carry out the provisions of this chapter. So if there are additional requirements related to the process for oversight, they can assess fees on the entity that they are reviewing. And it would be done through rules under this. So the committee could certainly, as you talked about earlier, if you wanted to increase those minimum and maximums, you could certainly do that. Or set some parameters, say up to a certain amount, cap it. However, the committee would like to do it. That's the proposal.
Representative Harper.
Thank you, Madam Chair.
Oh, you need to turn your microphone on, please. Yeah, going back to page 9, the assessment, I agree that what I'm trying to understand, because I don't remember all the conversations we've had, what was the connection point to do the assessment with the carriers to begin with? I mean, how did we get there? And there must have been agreement at some point that this made sense? And how did we get there? Does anybody remember that?
I mean, I think it came out of the commission,
The what?
the commission. Remember, this is based on
Right.
recommendations from the
Right.
hospital commission.
Yeah, so, okay, because some of these are things we've already changed and now we're doing additional changes. So these were all, so I should assume then that everything that's still here were recommendations by the commission. Is that
And
correct?
some of the underlying recommendations were based on legislation that was considered by the committee last session, LD 1972, in this particular case. So some of the language like related to the assessment was included in that original legislation that was carried forward in the commission's recommendation.
Well, I have a similar question to following up on Rep. Foley's comments about the confidentiality of the information on page, I've lost the page now. But there's a short list. Oh, here it is on page 10 and 11. I would like to remember why the commission or previous legislation thought that was necessary to get that information. If we're now going to take it away, why we were asking for it in the first place?
But he's here, can answer that question.
Yeah.
Do you remember that coming up?
Yeah, I mean, I think just as we're trying to sort of understand the landscape as it exists, and particularly like what is out there, this information seemed important and helpful. But again, in the interest of trying to make compromise and trying to be sensitive to stakeholder concerns, some of it was removed, figuring that we could still, small steps, I guess. And this would be a good first step.
I mean, I think just in general, the reason that you would put that kind of information is trying to figure out kind of the organizational chart, who really owns what, because sometimes companies set up sub-companies and shell companies and, so how can you track all that? And one way to do that is by these different numbers. So I'm just talking generally. I wasn't involved in these discussions, but Representative Foley, you on the commission.
Yeah, well, the commission didn't talk about these specifics. We talked about the generalities of why we want to do that, but we didn't get into the specifics of it. But I mean, and I don't disagree that information is helpful. I just disagree that it should become public.
Right.
And I have the same concern on page 12, number 4, where we're still going to allow identification numbers, tax identification numbers. I think anything that has to do with tax ID numbers, whether they're personal or corporate, should be private. We know a lot of people do bad things when they get a hold of your social security numbers or your tax ID numbers, and I just think that any place in here, and I don't know if we can do a blanket, anything in here that's deals with tax identification numbers or those sort of things should be.
If they're not already public, right?
Yeah,
Like
that's
the
right.
national provider
Yeah, that-
identifier is already public, so, yeah, Representative Olson.
Thank you, Madam Chair. Back on the assessment thing, I think we're kind of losing track of where our intent was behind this thing originally. It's trying to look at the private equity firms and whatnot coming in there. So essentially, you're looking at, you've got a one-time review of that. I don't have a big problem with a one-time fee for doing that review initially. But to then have an annual fee that goes across the board, I think that's a reach beyond where we were trying to get to. So I mean, I don't have a problem with the one-time fee, because there is work that needs to be done. And I would say that what they want to look at there is that sliding scale, and is based on the value of the acquisition or whatever. But that ongoing fee seems to me that we're kind of hitting people for something that we're not trying to keep track of.
So it sounds to me like we do want a number of changes. The question is, there's two ways we can do this. We can ask Colleen to redraft this kind of with the input she's hearing from the committee and bring it back for language review, at which time we would have to reconsider and vote on it. Or do you want to try to go into work session now, reconsider, go into work session now, and go through all the changes? What are people thinking, Representative Foley?
I think it would be helpful to see it, to have Colleen draft it so that we can see it. I do better seeing things than to try to forget what I'm
Yeah.
thinking.
Yeah. Colleen, do you think you have a good sense of what the committee was thinking?
So-
No, and then again, we might change it.
Well, I don't know. So, I mean, I don't know if you made any decisions, but I could certainly like bring you back a draft that strikes the assessment. Or makes taxpayer identification numbers confidential. And makes the other clarifying changes. Is that what you're thinking? Or are you thinking
Yes.
like
Yes,
just those?
yes.
Just those? Okay.
Those are the big ones.
Yeah.
That I'm hearing.
And then that's the question, like, you want to see like
You
the
can-
other suggestions or not?
You could, I would put those in there and, put a question mark next to
Yeah.
them or whatever, so that we'll remember to discuss them.
Yeah, okay.
I guess
That would be fine.
Sure.
So if we're going to strike the assessment, is the thought that we'll increase the initial fees, or we'll assume that this is going to go to the table?
That would be a question.
Yeah,
It
I
probably
don't
will
know
go to
that
the
we-
table no matter what,
It's
but
gonna go to the table. no matter
I don't
what,
know.
right? Yeah,
I can't say for certain.
right. I don't have that kind of insider information that says if we set the fee at a certain amount, it won't go to the table. Maybe you do, but I don't.
Well, that was the sort of the point of like not needing it to go to the table. And that's fine if it does. It certainly can, obviously. So, yeah.
Yeah, I think it would go to the table in any event, whether that assessment was in there or not.
I think there's a difference between whether it needs a general fund appropriation versus whether or not it goes to the table. And even if it doesn't need a general fund appropriation, if the assessment stayed in there, it still may need to go to the table because it's just sort of narratively impacts the general, it's just, those decisions kind of are made differently. So like globally, like the bill may go to the table because it may impact the general fund, but it may not need a general fund appropriation to get enacted. Those are two different things. And one's easier to move off the table than the other, but yeah.
Okay.
That's
Well,
what I
don't-
mean when I say it might go to the table anyway, is just because globally, I think it will probably say something about it having an impact on resources of the general fund or the department generally.
Well, I don't have a magic ball, but my guess is if we remove the assessment, it will go to the table for a general fund assessment or a general fund.
Representative Chimino,
Do we also want to add about?
if you could turn your mic on. Sorry.
Do we also want to add about exempting the privately owned dental
We had
practices?
said put that in there with a question mark, so we'll discuss it.
Yeah, big question.
Thank you.
Big question. We're not gonna, we're not gonna fight about the size of the question mark, but it's gonna be a question mark. Representative Foley.
On the assessment, again, I have no problem with the assessing of the fee. I would just simply say if we could strike out the part that says the department shall also assess on an annual basis.
Yeah, that's the. that's
Just
the part we're
struck that out, but leave the fees, and I would not have a problem increasing the fees.
And I think that's a discussion.
You know, maybe go 2 to 10. Because if an entity is doing this, then they should be the ones paying.
Yep. Okay. Let's put that in there and discuss it. Representative Arford.
2 to 10?
Yes, thank you, Madam Chair. At what point in this process will we see a fiscal note?
Well, we need to finalize. the
No, I know,
language.
but,
Once the committee decides on an amendment.
Right.
and we will have to see the fiscal night, no, excuse me, before we report it out of committee, correct?
Correct.
Okay, thank you.
Always. Yep.
Yeah.
Okay. I think you have enough, Colleen, to.
Okay, yeah,
That's
so I'm
another
just gonna
draft.
run by the changes that I'm gonna make. Add a potential exemption for privately owned dental practices from the definition of healthcare entity subject to review under material change transactions. I'm gonna clarify that we're not just talking about physicians, we're talking about providers and the exemptions. We're gonna propose removal of the assessment and doubling the fee from 1 to 5 to 2 to 10. We're gonna clarify in the reporting section, I'm gonna make those clarifications for those provisions that are exempted. I'm gonna make sure that those aren't shared. Make sure it's consistent for those paragraphs that are being removed. They're not being referred to in the subsequent subsection that requires MHGO to share that information. And then we're gonna clarify that to the extent that the information listed in paragraph D, those 4 subparagraphs, to the extent that they are not already publicly available, they're confidential in addition to taxpayer identification numbers that are someone's individual social security number.
Yes.
So I think those are everything. Those are the changes. If there's anything else, let me know and I can add it, but that's what I had on my list. Okay.
All right, thank you. Recontinue. Now, the other language review.
Are we going in order?
Yes, we are.
Okay. Oh, good. Representative Morris is here just in time. Talk about LD 519. But I think if we're going in order, that's the first one.
Yes, it
Right?
is.
Okay.
Yep.
So the committee will recall that you reconsidered your vote on LD 519 at your last work session on the 12th of March and decided in place of the prior version, which had a section 1 that authorized a potential increase in the per member per month assessment from $4 to $5 per member per month. You were going to replace it with the requirement that there be an annual review and have an ability for the committee to report out legislation. And so my proposal to accomplish that is in these 2 sections at the front of the amendment. The rest of the amendment stays the same in the sense that section 3, which used to be section 2, is the requirement that the superintendent of insurance will calculate a premium assessment equivalent to 1.5% of premiums for fully insured plans, and then they would identify that number, and then there'd be a requirement to transfer that amount from the general fund to support the reinsurance program. But in section 1 and 2 is the proposal to kind of accomplish what Representative Morris had proposed in the committee's reconsideration. So we talked about last time whether it be unallocated or allocated, so I came up with a way to allocate it. And you could tell me whether or not you think it works or whether we need additional changes. But in subsection 1, there is a current requirement in the Magara statute that requires that there be an annual review of the Association for Solvency. And Magara is required to submit that annual review to the Superintendent of Insurance. So I'm proposing that they be required to submit that also to the committee as part of the annual report. And then under the current statute, there already is language that gives the superintendent the authority, if they determine that the funds of the association are insufficient, they may order the association to charge additional assessments. So say under the current law, it says they have an ability to assess up to $4 per member per month. They're at the top now, but if they were at 3, you know, that the Bureau of Insurance could say, you need to exercise your statutory authority up to that 4 or raise it somehow. So I proposed also clarifying that to say if the superintendent orders the association to charge additional assessment, that the superintendent has to tell the committee that they're doing that. And then in section 2, in the annual reporting requirement that Magera has, it would require beginning next year that as part of their annual report, Magera should recommend to the legislature whether to continue, modify, or eliminate the assessments that are currently authorized under statute, which if these changes go forward, it'll be the $4 per member per month, which is in current law. And could make recommendations to the committee about whether they think additional statutory or structural changes are necessary to support the need for reinsurance. And then it would give the committee of the legislature having jurisdiction over health insurance matters, conduct an evaluation of the recommendations made by the board, and would give the committee the authority to report out one bill, based on that evaluation to any regular or special session of the legislature. You could change that to legislation if you wanted to give more than one, but this is a singular bill. But it would allow an annual review. They would make recommendations, you know, A, we think our assessments are good. B, we think our assessments need to be changed in some way, either up or down, or C, we think because we've gotten so much general fund money, we can eliminate it.
Yes.
Wishful thinking, probably.
Sorry.
And, or make statutory changes, and then the committee would have the ability to do it annually, make this review and make changes.
That's great.
So
Well,
that's
We'll do
the
amendment.
revised proposal.
Good job, Rep Morris.
Okay.
Nicely done.
So that's 519. And then I'm going to
2162.
next. So 2162, there are 3 amendments.
Oh, great.
Here for you to review. The first one is Report A. That's supported by 11 members of the committee, I believe. I did not attach for you, I neglected to attach for you the voting sheet, but the 2 subsequent amendments are supported by each individual member. So the final vote was 11-1-1. So 11 members support this first version of the amendment, which again is based on the prior version that you saw at the work session. It adds an emergency preamble and an emergency clause. Based on the language that you saw previously, the particular change is on page 3 in section 1500 RR. Subsections 1 and 2 would have a delayed effective date. So beginning February 15th, 2027, the ban essentially would be in place that would say deployers would not be permitted to make any chatbot operated or distributed by that deployer with human-like features available to minors to use, interact with, purchase, or converse with. And then that would be the chatbot with human-like features. And then subsection 2 would make the same requirement with regard to social artificial intelligence companions. Those 2 statutory sections would take effect February 15th, 2027. Subsection 3, which was the mitigation of harm provision, which would require deployers to implement and maintain systems to detect, promptly respond to, report, and mitigate situations in which a minor indicates to a chatbot that they intend to harm themselves or others. That would go into effect immediately under this proposal. Doesn't make any other changes to the version that you saw when you took the vote. It does to the statutory provisions, but it does add an unallocated section, which is section 2, that would direct the Attorney General to convene a stakeholder group to review the provisions that would be enacted consider whether the provisions as drafted, including the definitions and the substantive requirements, should be further amended to clarify the provisions or address unintended consequences, or whether the adoption of rules is necessary because the legislation would authorize the AG to adopt rules. Stakeholder groups shall review other laws in other states, recommendations related to best practices for regulation of AI. No later than January 15th, they would submit a report on the stakeholder group's recommendations, including any suggested legislation and any proposed rules they think are necessary. The committee would have the authority to report out a bill to the 133rd legislature in 2027. So that's the majority amendment.
It's good. Representative Flynn.
Thank you. Quick question. Does the AG office just respond to complaints or do they monitor what's happening on these sites?
In terms of like their enforcement,
Yes, for age verifications, such.
I mean, I don't want to speak for them, but my sense is that they probably would most directly respond to complaints. But to the extent that they would have resources to allow them to monitor, they would monitor. I guess that would be my answer.
Representative Arford. Thank you, Madam Chair. So thank you. I think this is excellent, what you've done with this. The only thing I want to clarify is if we pass this bill into law, then as immediately the system 3 systems to detect, they have to start developing them. There's no timeline on that, though. They could spend the next 5 years developing these systems to detect and respond when minor intakes intentional harm. So I'm suggesting that we put some sort of a timeline on there, or at least maybe not a timeline, just say, I mean, I don't know. I don't know how soon, how long. That was one of my concerns.
As I read this, it would require them to have it in place on the day, that, it would be when this is effective,
Okay.
they would have to have this in place.
Okay. Great, super. Thank you for clarifying that. And then the other clarification is that between now and February 15th, again, if this bill goes into effect, there can be ongoing the developers, deployers can continue to develop the artificial intelligence, continue to evolve the technology and the use of it here in Maine. And then on February 15th, 2027, if nothing else changes, if the Attorney General's group come back and says, stay the course, we think this is perfect, just do what you have done with this bill, then
You're so optimistic.
yeah, but this is key to me because if in fact this is the way it works, I may well change my vote. On February 15th, if that's what they say, everything stops. All these human-like chatbots that pretend they're people are going to be basically banned.
The ban would go into place. Yes.
So there's nothing grandfathered, in other words.
Correct.
So like my amendment says we start it now. And that was one of my concerns, that if we waited, the development that would happen would somehow, we wouldn't be able to grandfather it. But you're saying that's not the case, that it will be, there's no grandfathering, they will cease to exist at that point. If
Well, I don't know that they would cease to exist, but they would be banned in
Here
the
in
state of
Maine.
Maine.
Okay. Yep. Thank you very much
Yep.
for that clarification.
Anything else on the majority report? Looks good to me.
Great. So that good segue to the report of B of Representative Arford, which really the only difference between the majority report and the minority report is if you look at subsections 1 and 2, there's no beginning February 15th, 2027, because Representative Arford's intent was that it would go into effect, all of it would go into effect immediately. It has the same reporting requirement, same language. It just would, the difference is the sort of prohibition on making these products available to minors in the majority report, that would be delayed until February 15th, 2027. And in Representative Arford's report B, if it was enacted as would it take effect same time as the other provision.
Yep. Representative Arford. Yeah, I have a question since this is my amendment. I don't know. I mean, I don't want to put anybody on the spot, but I'm curious if there's any support whatsoever in this committee for starting a pause now and instead of waiting until February 15th, 2027.
if there's any interest in that whatsoever, if I am in fact the only one, I would really appreciate knowing if there's any other interest in this. So not hearing from anybody, I'm assuming that's a no. In which case, I would like to change my vote to the majority report because I have no bandwidth right now for causing extra work for myself or anybody else at this table.
Okay. Can we guess for 2 minutes?
Sure, but let's do the other report to go through. So
Okay.
give Representative Morris a chance.
So Representative
Look at
Morris
his
can look at his report C, I think it'd be report C. Which would, in place of the majority report and report B, replace the legislation with legislation modeled on New York law, which regulates artificial intelligence companion models. It would apply to all users, so not limited just to minors. But the substantive requirement is in the middle of page 12. Operators may not operate for or provide an AI companion to a user unless such AI companion contains a protocol to take reasonable efforts for detecting or addressing suicidal ideation or expressions of self-harm expressed by a user to the AI companion. That includes, but is not limited to, detection of user expressions of suicidal ideation or self-harm, and a notification to the user that refers the user to crisis services providers. It requires notice. So an AI operator shall provide a clear and conspicuous notice to the user at the beginning of any AI companion interaction that they're not communicating with a human being. It allows the notice to be verbal or in writing, must be provided at least once per day for a single AI companion interaction, at least every 3 hours for continuing interactions. It has a slightly different penalty provision, and requires that any fees, and it should be 15,000 per day. That's a typo in the,
So notice that, I'm like.
so I apologize for that, yeah. And then would require the fees collected for violations to be deposited into a suicide prevention fund that, I proposed would be administered by the Attorney General. It was done differently in the New York law, and then would require some annual reporting. But the draft based on the New York law, I think, was distributed to the committee at the work session. So this is just a cleaned up sort of Opla-sized version of that earlier draft that you
A
saw.
main Opla size.
Right.
Does that look good to you, Representative Morris? It's your report, so.
Yes.
All right, so, Representative Matheson.
Thank you.
So if I'm reading this right, this basically just puts guardrails around all. Okay, thank you.
Okay, so did you want to caucus? Just for a second. Okay, so we're going to briefly caucus. We'll be right back. So we are back on LD 2162 and we're fine with the language as is. So everyone okay with closing the language review on that? Okay, all right. Okay. Next is 20.
So leaving it the way it is. No.
Yeah.
Okay.
No, no. LD 2208.
Oh, two more.
Yeah.
2208, there are two amendments to 2208. The first, the majority report really just reflects the legislation that you saw at the work session. The only change to the prior language in the majority report that you verbally made was on page 5 of the yellow was, and the bottom of page 4, the top of page 5, changing the funding provided to Megara from a one-time general fund appropriation of $80 million to an ongoing appropriation of $40 million. So the rest of the language stays the same. And the minority report does that same thing with regard to the Megara funding, $40 million on an ongoing basis, and also retains the section of the majority report related to funding for healthcare, the healthcare premium stabilization fund, which was the 17.3 million one-time funding for state subsidies for those to replace the loss of federal premium assistance. That was 2208.
Well, it's fine. And
then the last is just showing you on the salmon colored sheet, the amendment to LD 2209, which was the resolve related to the Oral Healthcare Commission. You'd seen this language making the changes to the stakeholder group, hadn't seen the fiscal note, which reflects minor costs increase to the general fund, minor costs increase to other special revenue funds. But my understanding is because it is minor, will not be referred to the special appropriations table if it moves forward for adoption.
yes, because it says it can be absorbed.
Yeah.
So, okay, great.
So that's it.
I think that's it.
All I had for today.
All right.
So what's the,
We are not meeting tomorrow. We are waiting for a substantive rule to be referred to the committee. And so I would anticipate we would be scheduling that, and I don't know what you have for other language reviews that are
So
coming.
we would
Holly?
have to schedule a work session on the combining of the licensing boards.
Yeah,
Bill,
that too.
And an anticipated public hearing and work session on a review of a major substantive rule. And then you just have language reviews. So that's all I anticipate you having left. So
So I
guess we'll
anticipate
figure
it
out.
would be one day next week, probably Wednesday again. Don't know that. Just, we don't know when that's gonna hit the calendar.
Right.
It just seems like, you know, we're gonna come back one more meeting, and I would just like to make sure we include all our work that we have left at that time. So I'm thinking Wednesday, but that's only if we get the referral for the major substantive rule.
Yeah, yeah. So the understanding is that the next committee meeting, it would be a public hearing and a work session, like we did today, sort of
And
public
then
hearing
any
on the new
language
bill,
reviews.
and language reviews.
Yeah.
So I'll bring 2201 back, and then 378 as well.
Yep.
Yep.
So we're getting there. Pretty